Oyez, oyez, oyez. All persons having business before the Honorable United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and its honorable court. Be seated, please. Case number 25-7017, PhantomALERT Inc., Appellant versus Apple Inc. Mr. Summers for the appellant, Mr. Kleinberg for the appellee.
Morning, Mr. Summers. You may proceed when you're ready.
Morning. May it please the court. This market definition appeal arises because the district court got antitrust law resoundingly wrong. For example, it fails to equate price and quality, and it focuses on Apple's status as a global company. This court should reverse on the merits, but a narrower path also exists. That would mirror this court's decision in Moyar, in which the court found that there were concerns with the district court's futility analysis and remanded for dismissal without prejudice. That would avoid affirming an incorrect decision or writing an antitrust treatise on this record, and it would avoid jumping ahead of the district court to merits questions about content moderation on the App Store that the district court did not decide below.
My impression was that the dismissal was without prejudice. Is that wrong?
So the dismissal of the initial complaint was without prejudice, but the court found that that amendment would be futile.
So if we were to affirm, that would be the end of the case.
That's correct.
Is there no dismissal without prejudice that could also be the end of a case? I mean, the question about whether it's preclusive and whether if it were not time barred, a new case could be filed.
I suppose that's possible. I think it's also possible that a dismissal without prejudice can lead to the end of a case if a plaintiff decides that the district court's analysis was right, and in fact it is, there is no way for them to cure. I think this is not that case. This is a case where dismissal with prejudice and a reversal or remand of the finding of futility would allow plaintiffs to, either proceed on the amended complaint or file an additional complaint that addresses some of the concerns that the district court raised.
Why should we take that route? It seems that PhantomALERT actually was responsible for some of the procedural confusion in the district court. Your brief says something about how it's standard to respond to a motion to dismiss with an amended complaint. I'm not aware of that actually being standard. So the fact that that PhantomALERT, filed late, it did a non-standard response to a motion to dismiss. You've had a lot of bites at the apple already. Why should we do a remand on the ground that maybe the complaint was inadequate and therefore should have been dismissed under 12b-6, but another opportunity should be made available? Why is that appropriate in this case? Is that A, is that what you're asking for? And B, why is that appropriate here?
I think either of two paths are appropriate. One would be a reversal on the merits, finding that the amended complaint did adequately state a claim. And I can walk through the various reasons why that's true. And I think we do that in our briefs extensively. Alternatively, the sort of Moyar remand that I'm discussing would contemplate a potential dismissal without prejudice that allows us to refile. And I think the reason that it's appropriate is because I think it hinges on what we're challenging. What we're challenging is not that we had perfect procedure below. That's not our argument. What we're arguing is that the district court's futility finding below was in error. And so plaintiffs were entitled to, under 1582, where leave to amend is freely given, there is a valid claim to be stated, and in fact that was stated here, that we can substantiate and have substantiated already. I think the court's finding of futility, just like in Moyar, I think the court called it premature or inappropriate in that case. And I think that's what we have here, where there are specific errors of antitrust law that, if affirmed by this circuit, would have ramifications in this circuit and beyond. And I think correcting those, pointing out that there are flaws in the district court's futility analysis and allowing the case to proceed would correct those and allow plaintiffs to, proceed on their case. I want to talk about the domestic market for COVID tracing apps, because I think that highlights one of the district court's errors, which is that, I think the correct way to read it is that Kodak's lock-in factors can be satisfied by policy changes that impact things like quality or innovation or choice. It doesn't just have to be price. But that's what the district court held. In 3 different places, it says...
Can we just back up? Do you think that the proposition that the App Store is a relevant market is a predicate for all of your claims?
Absolutely not, Your Honor.
Why not?
Because in count 3, which is a monopolization claim for the COVID tracing app market, there's no need to plead the App Store. That would also, count 3 avoids the Amex concerns.
The way your count 3 is pled is that because the App Store is the only way for iPhone users to access apps, they are essentially hostages as to the sub-market also of COVID-19 tracing apps. And so if it were the case that iPhone users can get apps elsewhere or just access them on their browser, your count 3 claim doesn't really hold together, right?
So that would depend on a number of factual questions, Your Honor.
It absolutely would. And as the plaintiff, it's your burden to plead under the interchangeability standards and cross-elasticity, at least some factual allegations that support your market definition.
And we've put forward that I think paragraph 87 and surrounding paragraphs, as well as the complaint as a whole, does talk about why COVID tracing apps are different than health apps and why they do require things like user-provided data that don't really make sense in the website context. I would point out that in every case that Apple cites in which there was some obvious alternative that the district court figured out that the plaintiffs hadn't figured out, that those cases had multiple opportunities, and in fact, usually after that decision, were given an opportunity to amend. That's things like Hicks and SciStar and Riley. I think Hicks is instructive because there, the Ninth Circuit said, look, in-person golf advertising is not its own market. Like every other kind of advertising would be a totally valid and substitutable alternative. But we're remanding with instruction to dismiss without prejudice because what's obvious to us isn't really how factual determination should be made at the pleading stage. Plaintiffs ought to be given an opportunity because we think things like websites are actually obviously not substitutes. And while I think we've pled enough facts to suggest that, certainly if that's the district court's primary concern, and if that's this court's primary concern, there are myriad allegations, like even more allegations that would make that even clearer.
The coronavirus reporter case said, among other things, that the plaintiff needs to make an effort to define the markets, needs to distinguish the markets from one another, and can't leave the court guessing at the boundaries of each. In looking at the complaint and amended complaint and briefing, I'm just going to list 10 articulations of markets. And then if you catch any of them I'll then ask the question. The US smartphone/tablet market, markets for the iPhone and its own tablets, the App Store, smartphone, COVID-19 related tracing apps in the App Store for use in the United States, access to apps via the App Store, coronavirus apps, access to COVID-19 tracing apps, COVID tracing apps on iPhone. It seems like there's some gap between each of those. In other words, that none of those have the exact same boundaries. So number one, if that's wrong, tell me why you think that's wrong. If it's right, tell me why we shouldn't conclude that you have failed to distinguish markets from one another and left the court guessing at the boundaries of each.
Thank you for the detailed question. The first thing I would say is I don't agree that those are each distinguishable. If you want to talk about, I could go through each of them and say why they fit into the three buckets. But I would just point out that the district court also agreed, the same way that we're arguing about on appeal, that there are those three distinct markets. And those, just for clarity, are the smartphone market, the app store market, and the COVID tracing apps market.
So, if my colleagues will indulge me and you, I do want to give you the opportunity to say what you said that you would be able to do, which is say how, I forget exactly how you phrased it, but on that point right there,
Yes.
even just like the first bucket you listed, the smartphone market, you talk here about the US smartphone / tablet market. Also the markets for the iPhone and its own tablets. Those seem like quite different boundaries than the smartphone market.
I'll grant that I think tablets are a challenging part of that. And I can talk about why I think we could proceed even in spite of that. But I just want to talk about the difference between sort of, I think it was like smartphones in the United States and iPhones. Market definition includes those two components, right? It's both the product itself and the geography in which it sits. And so I don't think there's a distinction between smartphones and iPhones within Apple's iPhone market within the United States. I think similarly, the access markets, some of which you listed, I think admittedly it could have been clearer, but I do think that access, the difference between the App Store and access to the App Store, at least to me, I don't see daylight between those. I don't see why those ought to be considered different markets. I think that to go off the coronavirus reporter case, which I think you cited at the beginning of your question, I do think that that was a case in which plaintiffs had 7 different opportunities to kind of reconfigure their complaint. And that's what they ended up with, was 15 different, as the Ninth Circuit said, sort of scattershot markets that have no boundaries between them. I respect the question, of course, and I agree that we certainly could have been clearer on some points about perhaps the exact precise boundaries.
Can you now give us your clearest definition, market definition? Just tell us what market you're talking about, and is it a market and are the market participants that are relevant the app developers or the phone users? Spell it out for us as clearly as you can. What market you are contending is at issue here?
I would love to do that. So first, we have the smartphone market. And all of these are within the United States. So first we have the smartphone, and there are 3 different markets, right? Just to be very clear. The first is the smartphone market. And that includes Apple's products as well as Google's smartphones, anyone that's making smartphones. I would say the participants in that market are 1, the companies that make the smartphones, and 2, the consumers like you and I that own those smartphones. I'll move on to the next one if there's no questions on smartphones. The App Store market is I think the best way to think about it is the way that consumers access apps on the iPhone. And the participants in that market are Apple, which provides the App Store, and the consumers that are using that App Store.
But Apple's not a participant in the market. Presumably the app makers would be participants. I mean, Apple also makes its app, but
so there are developers that are engaged in that market, right? Because otherwise there would be nothing on the App Store, right? But the App Store is, I think the best way to understand the App Store is.
Can I try it?
Of course.
Are you saying that the market is ways for iPhone users to access apps like this, and the only product in that market is the Apple App Store?
With the exception of the phrase "like this," I would agree. I mean, obviously, this is one of the apps.
Well, I think that's even harder for you. So the market is methods of accessing apps for iPhone users.
That's correct.
And as the Riley case and as common sense would say, if I want an app and I have an iPhone, I could download it through the App Store, but I also could look at it on my browser. I could also go over to my laptop and use it on my laptop. And so I would expect in a complaint that says, wants this market definition, to have some allegations that go to those questions, which are essentially cross-elasticity questions about your market definition.
So I do want to make a distinction here because I think it's important to think about the fact that market definition, right, has to be defined in relation to the conduct that's being challenged. And so I think it kind of pushes me into the COVID tracing app market, which I do think is kind of the central market here. To explain like why that's so distinct, I'll do that, but then I promise I'll come right back to the App Store, which is thinking about websites specifically, right? So the first thing is to know that on iPhones, the reason Apple's the only participant that's providing an App Store is because no one else is allowed to, right? The Epic litigation clearly makes that clear. But the reason that so you couldn't download the PhantomALERT app if it wasn't allowed on the App Store. And the reason that you can't use something like PhantomALERT on your web browser, whether it's on your laptop or even on your phone, is because there's just fundamentally different capabilities here. And we allege—
a well-treated complaint would talk about those different capabilities, right? It wouldn't just say COVID-19 tracing is different from other health apps. That's your best allegation. That has nothing to do with suitability of your service on a web browser.
So I think that there are allegations about the sort of specific reliance on user provided data and other things like that. Like a lot of that comes down to things like continuous location tracking, which doesn't happen on websites, right? If you were, as I and many other people were, like traveling either between states or cities during the heart of the pandemic, right? Put yourself in those shoes. It would be important to you potentially to have an app that was, as you passed through a hotspot, would tell you something like, would send you a push notification saying, hey, like maybe don't stop at a restaurant here. And that's not substitutable for me like pulling over and like opening up my laptop or even like trying to go on my phone. And
none of that is alleged in the complaint, even argued in your briefing. We do allege, we do certainly in the briefing, in the reply brief, we talk about the importance of push notifications and continuous location monitoring. And I think all of that is in response to what I think the reason that it's not pled in the complaint is, my client is an app developer. To him, it I believe is obvious that things like websites are not substitutes. And so the district court submitting that it thinks those are obvious substitutes are the reason that Hicks and Systar and Riley gave plaintiffs a chance to amend in response to but at least you would have argued on appeal. The district court got that wrong for that reason. And you said that the third market is COVID tracing app market. You also have alleged and argued a submarket of access to COVID tracing apps or the COVID tracing app market. Is the word access doing work for you?
I don't think it is. I think the complaint is talking, when it uses that word or not, is talking about consumers needed the apps, right? And whether you call that access or whether you call that a market for those apps, I think is indistinguishable. And I think that certainly, right, just to bring us back to the futility analysis here, I respect that there are ways that the complaint could have been clearer, but the district court's finding wasn't that the complaint wasn't perfectly clear. It was that no complaint could have stated a claim on the facts here, right? That's the test under FOMON. That's the test under Moyar, is that if for the district court's finding to be correct and to be affirmed wholesale, it has to be the case that there is no complaint, right? That it would be futile for us to amend. And I think that I do think that we were clear both in the pleadings. I think there's enough there, and certainly like in our briefs on appeal. But even in this discussion, right, if there are ways that it could have been clearer, that doesn't get it over the line into futility. Because if striking the word access, for example, from the complaint would have made it adequately state a claim, or striking the word tablets, that doesn't mean that amendment would be futile. I think that's sort of where I hope the court would focus is whether or not there is a claim that can be stated here. I think it was stated in the amended complaint, but I certainly think that there's more.
On the geography point, the amended complaint, and I think it's at paragraph 24, talks about international uses, including use in Africa. But in light of that, what facts do you think are alleged in the complaint that explain why the App Store and the COVID tracing markets are limited to the United States?
So first, I think there's two parts of that, as I understand it. One part is the allegation that it is limited to the United States, and the other part is why that's justified. So the first part, I would point Your Honor to paragraph 16 for the smartphone market, paragraph 87, which talks about COVID-related tracing apps for use in the in the App Store for use in the United States. And so I think all of that makes pretty clear, like we are talking about the United States. And then for why that's justified, there's a few reasons. One, we do talk about how there are dramatically different regulations within the United States versus elsewhere.
Versus Europe, but I don't know about the United States versus everywhere.
That's true. It's true that we didn't list every other continent that might have different rules. But I think that the sort of regulatory framework within the United States, that I think in paragraph 16, we also allege that consumers in the US could not avoid or defeat an increase by purchasing and importing from abroad. That would include the whole rest of the world. I think that there are reasons to think, right? Just to be really concrete about what this geographic market means, it's limited to what users can access within the United States, right? That might be the US App Store.
I think I'm following that part, but it's the why that I'm still a little unclear on. As I understand it, an app developer in the US can sell on the App Store in the US and can sell to a consumer using the App Store in Africa. A developer in Africa can sell to a user of the App Store in Africa and a user of the App Store in the US. So why have you properly defined the market as just the US?
I want to be really clear about one of those points, which is that, and hopefully the other one too, but the apps that are developed like in Africa that are available for users in the United States are within our market.
Okay, what about an app developed in the US that's available to a user in Africa?
So an app developed in the US for a user in Africa wouldn't be included. And the reason I think is pretty straightforward, that the question under colon and other cases is that the question is what users can like functionally switch to defeat a price increase. And so I think I do think there are facts sufficient to this in the complaint, but I think the logic of it is important to explain here, if I may, which is that a user, let's say users, even like tons of users, were really upset about the restrictions that Apple put in the United States. And they said, like, we really don't like that. We want our COVID tracing apps from PhantomALERT and the hundreds or thousands of others that were kind of clear cut by Apple here. The question is, like, could they successfully defeat, would they successfully defeat a price increase by going abroad to get like another app that might not even be designed for the United States? And I think sort of at an intuitive level, that doesn't make a lot of sense, right? It was a global pandemic. We talk about deaths and infection and spread. Having the idea that people would like travel to get access to apps abroad in order to defeat Apple's price increase is another one of those things that I just don't think makes that much sense, but was one of the foundations of the district court's holding, in part because of another error the district court made, which was focusing on where Apple sells, kind of similarly to thinking about a US app developer selling in that operates internationally or something. Like, that's just not the right test. The right test is what consumers have access to, because antitrust law looks at that interaction between what consumers can do and how the company will respond. And here we have a circumstance in which consumers, it doesn't whether or not Apple operates abroad doesn't affect consumers' ability to go abroad to get COVID tracing apps. If that were true, it would mow down lots and lots of the Supreme Court's and this court's and other antitrust cases that have a US market, despite having a global enterprise.
Returning to where we started, I just want to make sure that I understand. As you understand it, at the end of the day, as the case comes to us, the district court dismissed with prejudice.
Functionally, yes, by finding that the amendment was futile. And that's what I'm saying is even if you're not with me sort of all the way on all of these factual predicates, or that the complaint did like quite enough, the amended complaint did quite enough to cross that line, there's still a big hurdle for the district court to jump. And that's why I think the narrow path following Moyar might be appropriate here and might be what this court opts to do.
That sounds like an argument that you're saying that both the district court thought it was holding that no other amended complaint could state a claim, and that we ought to remand because if it did that analysis, and I'm not sure you presented that argument. In fact, the reply brief says this court need only evaluate de novo whether the amended complaint stated a claim. That sounds very different from the argument you're making today.
I just want to be clear that is, I stand by that being all that this court needs to do. And I think, we can, if there's other like questions on the other parts of the merits analysis here that the court got wrong and for why the amended complaint like substantiated those and is enough, I think that's would be perfect. Personally, that is my preferred holding for this court to say on the merits, the amended complaint stated a valid claim. So I'm saying that is all this court has to do. But I guess I wasn't saying that that's all the court can do. And we quote.
But the other side of that is you presented it. All we're doing is evaluating whether the proffered amended complaint stated a claim. And I took that to be that we could say, no, it doesn't. And the order of the district court, although appealable, it's not clear that it forecloses your refiling. But you just said you think it is clear that it forecloses your refiling a new suit with better allegations.
I think it's clear, but I would be very happy if this court didn't think so and remanded saying
that you've waived that expressly in response to Judge Walker's question.
Would you mind explaining how, Your Honor?
He said, you understand the dismissal to be with prejudice. And you said yes, because the district court decided that amendment was futile. Judge Garcia said, okay, you're understanding that to be more than saying that the amendment you proffered was futile, but that generally any amendment would be futile.
I want to be clear that is how I understand the district court's orders. What I'm saying is if this court has a different opinion and thinks that reading the district court docket, it would be appropriate to amend and a sort of any kind of clarification of that would be very much appreciated and would allow the case to proceed. That's a perfectly fine outcome for us. I appreciate that wasn't our sort of forward position. But if this court has like a very different understanding, and certainly much more than I do about how both district courts and circuit courts review these kinds of orders, and if that's the finding is that we do have an opportunity to amend, that's a perfectly fine outcome for us. Thank you.
Thank you. Mr. Kleinbrot, morning.
Thank you, Your Honors. May it please the court, Julian Kleinbrot on behalf of Apple. And I think I'd like to begin where Judge Garcia's questions were leaving us off, which is that the standard that the district court applied under this court's precedent to evaluate whether amendment would be futile has been undisputed in this appeal, at least up until a few moments ago. Under this court's precedent, when a plaintiff tenders a proposed amended complaint, futility is evaluated on whether the proposed amended complaint states a claim, applying a typical 12b6 analysis. That is what the district court did. It properly concluded that no claim was stated on multiple grounds, and it therefore deemed the proposed amended complaint to be futile. I think that the district court, like this court, was grappling with the fact that the allegations can be a bit difficult to parse, to borrow Judge McFadden's words. But I would like to say that while we've heard a lot about the COVID-19 app market, again, to one of the questions you asked, Judge Garcia, I think the App Store only market is the best one to start with because PhantomALERT has said that its arguments to define a single brand COVID-19 market, whether it's a sub-market or not, are the same as the ones it advances for the App Store only market. And so if the App Store only market goes, then I think so goes the rest of the case. And if I can address a couple of points that were made by PhantomALERT, I want to start with allegations about substitution and cross elasticity of demand, and this case's similarity to coronavirus reporter from the Ninth Circuit in that regard. The markets in coronavirus reporter were admittedly alleged in a confusing manner, but the Ninth Circuit went on to say that even if we evaluate them as the plaintiff there had tried to articulate them more clearly, which indisputably included an App Store only market identical to the one that PhantomALERT alleges here, they have failed to substantively allege a plausible App Store only market. And the reasons the Ninth Circuit reached that conclusion are the same reasons that apply to the complaint here, which is the failure to allege the prerequisites to a single brand market under Kodak, as well as the general failure for any market to allege facts proving up or that would prove up a market under general principles of cross elasticity of demand and reasonable interchangeability of use. And the Ninth Circuit there found the amendment to be futile as well. Importantly, in this a very similar posture, while the plaintiff there had taken multiple amendments prior to the dismissal order, the district court there did not give the plaintiff an attempt to amend again after its dismissal order. And the reason it did not do so is it said the plaintiff has had an opportunity to amend. It has had an opportunity to amend in the face of Apple's arguments, and it has failed to state a claim in this proposed or in the amended complaint there. It's the same point here. PhantomALERT filed an original complaint. Apple moved to dismiss. It put on the table all of the defects that the district court found in the complaint. And when it tendered a proposed amendment complaint in the face of all of Apple's arguments, it still failed to state a claim. And I think on that record, just as in coronavirus reporter, it's perfectly appropriate to find an amendment to be futile. With respect to the COVID-19 app market, the allegations to which counsel was pointing, I don't think support the argument that a COVID-19 market was appropriately pled. There is a distinction, Judge Pillard, between an access market and an app market. You were expressing some, I think, understandable confusion about how does an app store market work? And the reality is these are what we call two-sided transaction platforms, where Apple is providing a platform that intermediates between two sets of participants, developers and consumers. So when we're talking about access, typically that is a shorthand for a transactions market, which is what the app store market is defined to be. If the plaintiff is trying to allege a submarket, that would be a submarket of COVID-19 app transactions. That is not adequately alleged in the complaint, and it seems to be conceded on appeal that that would not be a proper submarket. So there must be a distinction then in the plaintiff's mind of what the app market itself is, which is not some kind of two-sided market, but some other kind of market in which the developer is the supplier and consumers are the purchaser, and COVID-19 apps themselves, not the transactions, the apps themselves must be sufficiently unique. And I think—
Counsel, you said that as to the App Store market, you think the deficiencies with those allegations can be framed as entirely independent of the Kodak single brand aftermarket analysis. And the Ninth Circuit in the coronavirus reporter treated this issue through the lens of the Kodak factors, information switching costs, et cetera. So could you just explain what the defects are that you see as completely independent of the Kodak type analysis?
Yeah, so in the Ninth Circuit, under the precedent there, which begins in a case called NewCal, carried through to Epic and then Coronavirus Reporter, the Kodak factors essentially form a preliminary set of threshold inquiries for a single brand market. These are the switching costs, the information costs, the change in policy considerations. What the Ninth Circuit says under its precedent is the last step in that inquiry is, even if you pass all of those threshold steps to define a single brand market, is the single brand market consistent with principles of cross elasticity of demand and reasonable interchangeability of use? So, and that again actually comes from Kodak itself, where it looked at all these things and said, we still need to check if our general market definition principles are consistent. So we can look at the threshold Kodak factors, or we can look at the generally applicable market definition principles. And in this case, I think both support the district court's decision. With respect to the COVID-19 app market, the allegations, I think most critically that counsel was pointing to, go to what Judge Garcia was flagging, which is whether or not COVID-19 apps are sufficiently distinct from other kinds of iOS apps. The critical lack of allegations here goes to whether there are sufficient allegations to show they are different from other forms of digital technology or software products that could be reasonably interchangeable. And so, for example, counsel was pointing to some allegations in the complaint about them being web browsing being distinct. Actually, what's referred to as distinct in paragraph 15 of the complaint are smartphones being distinct from feature phones because smartphones have more powerful web browsing technology. That doesn't say anything about whether a COVID-19 iOS app is sufficiently non-substitutable with an Android COVID-19 app or a website. What the complaint does say about COVID-19 apps and what PhantomALERT has argued on appeal is that they are portable, or that PhantomALERT's own app was intended to be able to have users input data about their symptoms and show users information about the spread of the pandemic. There are no allegations that a website, which could be accessed from the browser on your phone or tablet, is not portable, or that websites or web apps, among all other sorts of things, couldn't perform similar functionalities. So it is the fundamental lack of allegations that go to cross elasticity of demand and reasonable interchangeability of use that the district court principally cited as the flaw in the amended complaint, and I think is a clear path to affirmance here. I'll just very briefly note that on the geographic market, similarly, the allegation that counsel was pointing to in paragraph 16 of the complaint is actually about phones again, not apps or app stores. So the problem was that even if we assume that they were trying to define domestic markets, there are not allegations that would support that anywhere in the complaint. The court did mention the fact that Apple is a global enterprise, but this court in Hecht and the Fourth Circuit in Cologne say that where the seller operates is part of the analysis. So the district court said, I have no allegations about where consumers can turn. I do have one allegation that suggests the seller operates globally. That seems at least inconsistent with the US market. It's similar, Judge Walker, to the allegations you were pointing out that the restriction, it says, affected developers around the world, affected and denied those developers access to global users. That's a paragraph 38 of the complaint on page 79 of the appendix. Again, part of the geographic market inquiry is who are the customers affected by the challenge practice. So the geographic market allegations are virtually non-existent, but the few things that do seem to speak to parts of that analysis do not support a U.S. market, and that is what Judge McFadden was citing, and we think that was perfectly appropriate. I see my time has expired, so unless the court has questions, we will otherwise rest on the papers. Thank you, Your Honors.
Mr. Summers, reserve time for rebuttal. Take your 3 minutes. Do you have any beef with the way counsel for Apple described the epic factors and their applicability?
I do think the Ninth Circuit has a slightly more expansive approach to the epic factors than Kodak itself does, but I think overall they pretty accurately describe, and they do include sort of a general understanding of cross elasticity. I think that's why, we talked about that and the hypothetical monopolist test and the things that support that.
You mentioned Moyer a couple times, our unpublished judgment from last year. And I took a look since the last time we were up here. There, the district court had dismissed with prejudice. The panel here faulted the district court for doing that, but it faulted the district court for doing that because there was a government regulation in the record. The district court cited it and quoted from it. And on the one hand, the district court said, well, the plaintiff hasn't identified any relevant regulations. But if you just read the regulation that the district court quoted, it was arguably relevant. And so the panel concluded, it was probably premature to declare futility. That seems different than here because your argument on futility seems to be that even if there is nothing in the amended complaint and nothing in whatever record exists, which obviously it's hard to have much of record at the motion to dismiss stage, I get that. But your argument seems to be, regardless of what's in the amended complaint or the record, the district court should not declare futility unless it can be sure that something outside the complaint doesn't exist to save your suit. That seems not what Moyer said.
So I want to clarify that Moyer is a mechanism that says that looks at the futility analysis and finds problems with it. Admittedly, those are different problems in Moyer versus here. I think here the problems with the district court's futility analysis are primarily legal, although it does also sort of assume and assert its own facts, like iPhone users probably also own Android devices. But I think the reason for this court, that I would encourage this court to think about that approach, is because there were legal deficiencies in how the district court approached antitrust law for this purpose. And so it's possible to look at that and then say, well, that was incorrect. And then Moyer,
we would still have to find something in your proposed amended complaint that would, under the correct legal understanding, save your suit.
And I think we've provided that in the both obviously in the complaint and then the opening and reply briefs, showing why that's sufficient. I just want to be very clear that we do think that the amended complaint is sufficient and can stand on its 2 feet, and reversal on the merits is appropriate for that. We think there's just sort of a narrower path that can avoid addressing some of those sort of treatise-like antitrust questions of dispute between the two parties.
I guess if we were to conclude that your amended complaint still does not state a claim, what is there in the beyond that you think we're supposed to look to say, well, it should have been a dismissal without prejudice? There's a number of legal errors, right, that we outline in the briefs. I think one of those legal errors is the finding of futility, that the basis for that finding of futility was incorrect, use the court's own suppositions, that those are the kinds of things. So if we read your proposed amended complaint and we think this does not state a claim, then we should say that this should be dismissed with prejudice.
I think this court could still say that it would be dismissed without prejudice because the futility analysis, right? I guess if you're saying, if the court believes that the complaint that it's futile to amend, then yeah, finding that dismissal with prejudice.
I know you think that your amended complaint stated a claim, but if we were to conclude that your proposed amended complaint does not state a claim, then it would be proper to dismiss the suit with prejudice, correct?
No, without prejudice.
What outside the amended complaint are we supposed to look to save a faulty amended complaint?
The district court's reasoning.
Well, okay.
You
can try to persuade.
I think it would be right if there was a 3-page section at the end of your brief that said, if given leave to amend, we would add the following facts, and those would address any deficiencies, even though we think this complaint is enough. And if you had moved for that in the district court and been denied, then that is kind of how these things usually come up to us. But there isn't a section like that in your brief. Or sorry, that's what you would like us to think about is, aren't there other facts they could allege?
I do think that's a little stronger than the position I'm advocating for. Think about it this way. I think here's an easy example from the district court, or one that seems easy to me at least, but might be wrong. But the district court, right, says that the sub-market, the addition of the letters, like the word sub in front of market, means that it's like incomprehensible and it can't be a real market, right? So the district court says, if the district court's opinion were just that, we're saying that it would have been fine if it had just said market, but it said submarket and that's no good, right? That would be, and then said, therefore it's futile. That's what I'm saying. That kind of analysis that's sort of facially wrong and facially sort of admits on its own terms why it's futile, why futility is wrong. That would be the kind of thing that I think it might serve to remand, saying that's not how we do futility analysis, or that's not how it ought to be done. And I think that's the kind of circumstance here where we have a number of errors that facially ought to be corrected. And I think dismissal without prejudice would be one way to do that, even if this court disagrees with me that our amended complaint adequately states a claim.
All right. Thank you. The case is submitted.
Thank you.
Case number 23-5311, Norwich Pharmaceuticals, Inc., appellant versus Robert F. Kennedy Jr. in his official capacity as Secretary of Health and Human Services et al. Mr. Prince for the appellant, Mr. Day for the federal appellees, and Mr. Killian for the appellant, Salix Pharmaceuticals, Inc.
Good morning, Your Honors, and may it please the court. When Norwich first submitted its generic rifaximin application to FDA, it sought approval to treat both IBSD, which is irritable bowel syndrome with diarrhea, and HE, hepatic encephalopathy. In ensuing patent litigation between Norwich and the brand Salix, the Delaware court concluded that Salix's drug product patent and IBSD patents were either invalid or not infringed, but that Norwich's then application did infringe Salix's patent covering the HE indication. The Delaware court accordingly issued what's known as a resetting order under the Patent Act, directing that FDA approval of that application not be made effective until the HE patents expire. As permitted, Norwich amended its ANDA to remove the infringing HE use from its application and requested that FDA then approve it. At that time, FDA correctly recognized that the application no longer contained the infringing HE use and certifications, but incorrectly concluded that it was still blocked by the prior resetting order issued in connection with the HE certification. That decision's inconsistent with the Delaware court's judgment, the plain language of the Patent Act as interpreted by the Federal Circuit in our very patent appeal, and the Food, Drug, and Cosmetic Act and its implementing regulations. I'd like to start with the judgment, if I might, because my friend suggests that I'm at war with it and I'm trying to ignore its language or collaterally attack it. But we fully accept the Delaware court's judgment was lawful It just does not mean, and as the Federal Circuit went on to explain, cannot mean what FDA says it means. Indeed, the Delaware court's judgment was the only lawful judgment it could issue in the circumstances, delaying approval of the ANDA before it and naming it by name because that's what we were talking about. And as Salix has argued before, that's what resetting orders always look like. The implications of FDA's argument.
Could I just clarify something up front, which I think you were hinting at? I completely understand the argument that we ought to assume the Delaware court understands the law, and so that's why we would look to the statute and the regulation to understand how this is supposed to work.
Yes.
But you are not arguing, and you didn't argue below, that the FDA in some sense was not bound or for any other reason was free not to follow that judgment if the judgment said effectively even an amended ANDA will be delayed until October 2029.
Yeah, I have my own views about how the statute should work in that circumstance, but that's correct. We've accepted that in this case.
Okay, thank you.
If FDA,
In your position is that the Delaware court's judgment does not block the FDA from approving your amended ANDA. That's what we're here about, right?
that's correct, because as the Federal Circuit went on to explain, a resetting order is a remedy for the specific act of infringement defined in, I think, 271 E4 or E2, which is the submission of an application containing an infringing use for which the submitter seeks approval.
Why did you move in Delaware District Court for them to amend their judgment?
Because we were admittedly confused at that time about what the patent attorneys in that case were confused about what the resetting order would do. And by the way, not just we were confused, Salix was confused too, because they were taking the other position then. Their position was this isn't going to have the effect you're saying it is. They were instead arguing that what we're going to need is a second litigation. Right. They said they need discovery on it. And so they were not taking the position that it blocked FDA.
It seems like in the dispute of what the order meant, you prevailed. Salix the district court concluded that Salix was wrong and you were right, that the order would preclude an amended ANDA's approval.
I don't think the district court concluded the district court entered Salix's form of judgment, not our form of judgment. And what I think the district court thought was happening was that, and I can understand why in retrospect it thought we were doing this. It thought we were effectively trying to get an advisory opinion that once we carved out the ANDA, it would no longer be infringing. And that's why the parties are discussing and the district court discusses in its reconsideration order that would be unfair because just because we carve out doesn't automatically mean it would be non-infringing in the future. It almost certainly does mean that. And in this case, it did mean that. And we know that because Salix sued us in the 370 case we're going to talk about and did not claim the application was still infringing on those grounds. But in theory, it would be possible for the carve out not to remove the infringement. And that typically comes up, for example, not in these method of use cases, but if you're reformulating your products to try and avoid an infringement.
Let me ask it with a bit of a hypothetical, because I'm not asking you to concede that this is what happened. But if you argued in the Rule 60 motion to the Delaware District Court that the order as originally issued by the Delaware District Court would preclude the FDA from approving an amended ANDA. And the Delaware District Court and the Federal Circuit agreed with you that that is the effect of the Delaware District Court's judgment. Then you have successfully told the Delaware District Court that interpretation is the proper interpretation, contrary to what Salix may have been saying in the Delaware District Court. Now you come here and you argue the opposite, that the Delaware District Court's judgment does not preclude the FDA's approval of an amended ANDA. And if that is what happened, that seems like an example. That seems like you have satisfied the elements of judicial estoppel, where you're not allowed to argue here what you argued to the Delaware District Court and successfully persuaded the Delaware District Court that your argument about the meaning of its original judgment was in fact the correct meaning.
Right, but we did not convince either the district court or the federal circuit that that was the correct interpretation of the order. In fact, those courts said, we are deeply confused and we don't know what you're talking about, Norwich. At JA 221, which is the Delaware court's explanatory order, it explains the scope of its order, and it says, this contains the HE indication which would infringe the patents. Norwich's proposed ANDA has that. I cannot rule on facts that are not before me, including the possibility of an amended ANDA, which it recognizes we're entitled to submit under the statute. That label is not before me. It's immaterial. The federal circuit was extremely explicit about this on appeal. It said, Norwich, I don't know what you're talking about because a resetting order is a specific remedy. It's directed to a specific infringing use in the application. It specifically says it does not cover non-infringing uses. And that's why the federal circuit said nothing in the Delaware courts.
The hardest fact for you, in my opinion, is that they never said it doesn't block your amended ANDA. And so it would have been the easiest thing in the world for the district court to say, when you come to them, understandably complaining, it's absurd for you to have a complete prohibition on our amended ANDA. It's not infringing. Easiest thing in the world for the district court to say, no problem. I don't even need to change the judgment because that's clearly not what it does. And as I understand your cross appeal in the federal circuit, this was essentially the whole issue. And again, it says you can file a new ANDA, but it doesn't say this whole cross appeal is of no moment because the judgment doesn't bar the amended ANDA. And I could grant you that that might make no sense, but they never said the judgment doesn't bar your amended ANDA. So why isn't that a powerful point against you?
Well, I too, of course, wish those courts had said it exactly in the way you're saying, but I think that's effectively what they are saying, especially the federal circuit, which says the statute is appropriately directed to approval of the particular uses involved in the infringement, not the non-infringing uses. And it described the remedy provision as delaying approval of the drug involved in the infringement. It did very explicitly say, Norwich says that this would block approval of a new ANDA, and the federal circuit says that's absolutely wrong. Nothing in the order suggests that. And I know this is difficult because it does say the word new, but we were never arguing in the federal circuit. Nobody was arguing in the federal circuit that it would block literally a new ANDA, right? The only new ANDA that was at all at issue at that point, this 370 wasn't even in the world. The only new ANDA we were talking about is the amendment to the 369 ANDA that we had then submitted. So that's what the federal circuit is talking about. But I totally get that the language is a little.
You just said that nobody was arguing that in the federal circuit?
Nobody in the federal circuit was arguing that the order would block approval of a different ANDA. So like
Of the amended ANDA?
No, we were only arguing about whether it would block approval of the amended ANDA.
Okay.
And that's
I was
why.
gonna say you were definitely arguing.
No, we were absolutely, that was our whole point. And when the federal circuit said, no, it would not block approval of a new ANDA, it's talking about our amended ANDA, but I recognize the language.
So what does footnote 10 mean? It says, it's exactly after this discussion.
Mhm.
And it says, basically, Norwich got approval of its amended ANDA. The tentative approval letter noted that final approval cannot be granted until October 2, 2029, as specified in the court order. There's not a next sentence that says, that makes no sense. The judgment doesn't apply to the amended ANDA.
Right. It does not address the issue because it recognized there was pending litigation in DC, and that's not the federal circuit's issue to decide. That's this court's issue to decide, and the DC district courts. So I think it was just reserving the issue without getting into the weeds of it. But if I could just take 1 minute, like the FDA's interpretation of this is entirely inconsistent with the entire way the Food, Drug, and Cosmetic Act is structured, which specifically tells it to apply timing rules only to the certification made in the application. Our application at the time it ran those timing rules did not contain this certification, and its regulations not only contemplate us doing exactly what we did, they require it.
Well, there are some distinctions. You chose to file an amended ANDA. I think the premise in the District of Delaware and the Federal Circuit was you could file a new one. And the distinction there, is that about filing fees, or is that about where you are in the queue, or why an amended ANDA rather than a separate one, or as you've done with the 370,
Sure. So there are
that one, which is distinct from the 369.
right. There are lots of reasons why you wouldn't want to file literally an entirely separate ANDA, including the filing fees, which are very significant, many hundreds of thousands of dollars. You go back to the queue in the line. There could be there's a possibility of an additional 30-month stay potentially when you file that application that would delay approval, not just at the back of the queue, but for many more years. So there's a lot of reasons why the statute wouldn't require you to do that, and why FDA's own regulations don't contemplate you doing that. Instead, they provide specifically you can either accept the patent court judgment and change it to a paragraph 3 certification, in which case the patent court's judgment is effectuated, or you can change your application to remove the infringing use, to make a Section 8 statement to that use, to carve it out, and then you're immediately approvable. It's literally what its regulations say. There's no other way to read the regulations, and I don't read my friends to even be disputing that. They're just trying to wish away their regulations and wish away the entire structure of the act that instructs them how it's supposed to read patent court judgments.
So given the other case, what are the stakes here, given the 370 case? So if everyone agrees you can file a new ANDA without the infringing use, and you've effectively done that in amending the 370, and what's at stake here for you?
So the simple answer is there's 2 separate applications, and although they're ultimately going to approve the same drug product, the statute allows us to have 2. And they're in different phases of the process, right? Here, we currently have an FDA's decision that says we can't be approved until the expiration of the HE patent. In 370, we have a different determination that says we're blocked by exclusivity. And for example, Salix in that case is arguing they have unique defenses to the approval of basically everyone said, just go file another ANDA. So we file the other ANDA. It's the 370 ANDA. And now Salix is saying, there needs to be a 30-month stay on that ANDA. You can't, the judgments that you spent years winning, they don't actually apply to the 370 ANDA. So they're intertwined in a way. It is true that at the end of the day, we will probably market the one of the 2 ANDAs on which FDA approves first, but there's nothing prohibits us from proceeding on parallel tracks. And nobody, by the way, in the case has argued that we can't do that.
Can you identify a case where a generic has amended after trial and then gotten approval without a court considering it in litigation?
I was not able to identify a case either way. And the reason why is because this is sort of a unicorn set of factors that came up, because we invalidated or showed inapplicable, depending on the patent, like the product patent and one of the use patents. So it's a unique situation where there's one unpatented use of the drug, but there's no broader prohibition on the drug. That does not come up very often. But again, I mean, FDA's, even if there's no example I can point you to, FDA's regulations provide the example. They tell you you can do it.
Maybe you've just answered my question, but if it's sort of completely consistent with the statute and regulations to do what you've tried to do, which is amend the ANDA once you hear which part of it is infringing, there seems like there's in the law emphasis about pre-judgment amendments. Like that's when you have to do it. And I'm having a little trouble squaring that with your position.
So the law will in certain circumstances allow you to do it, but you're typically doing that and I'll answer the question in a couple of days because there's reasons why you would want to do that. But typically those cases are not about method of use patents, but are about formulation patents. So you're in the middle of trial. it looks like, or you get a determination that your formulation is going to infringe, and you said, well, wait, I can reformulate the certification, or sorry, reformulate the formulation and avoid that infringement. And everybody wants it all to be resolved at the same time. And the reason an ANDA might, for example, want to do that is because if you're litigating in this pre-approval posture, there's not the possibility of damages. Right. So you don't have to do it that way. And the act would allow approval if you didn't do it that way. But if you launch, you can subject yourself to some pretty substantial damages in some circumstances.
So the district court thought that this Faring case from the Federal Circuit was analogous. I'm just going to say how the district court read it, which was it thought that at least the Federal Circuit thinks in a situation like what we have here, you do need a change to the judgment, and that's discretionary with the district court. Can you give us your distinction of that? Is it distinguishable, or is it just
well that's a formulation case. It's exactly what I was talking about. Okay. And by the way, I think that case actually supports exactly what I'm saying, because that case very explicitly holds that when we're talking about the application that you're litigating in the patent court, it's the operative application. It's the application as amended at the time you're litigating it in the patent court. So I think that case is actually.
But so why is a post-judgment change of your formulation different in a material way from a post-judgment change in your intended use?
Because we still need to certify to that formulation match. It doesn't work like method of use patents where you can literally drop it out and take it out. If there's no more questions,
So, I mean, this is a question I have, and maybe it's for your friends on the other side, but one of the responses of the district court and of the agency is, you chose how to package your ANDA, and you kind of have to live with that. And I guess why? I mean, if it's got components, and I take your answer to be why you don't file sort of more modularly, like an ANDA for one intended use and a separate one for another intended use, so you don't have this problem. You can just, okay, that one's infringing, we don't pursue it, but the ones that are non-infringing are standalone. They're not, tied up with one that's infringing. So one answer is to do it that way, then you'd be paying a lot more.
Well, it's paying a lot more, and it's entirely inefficient, because I take your question to be, well, why wouldn't we go in with the skinniest label possible, litigate that, get approval, and then add the uses on? And the answer is because when you add those uses on, you get subject to an additional 30 months stay. I mean, it would take forever.
And you couldn't do it all simultaneously. Like we have this sublabel, this sublabel, this sublabel, and if we win them all, we put them all together.
Right. Yeah.
That's just not something.
That's, if I understand the question, that's not a thing. Yeah.
Can't be done, or wouldn't be done. Which is it? It wouldn't be done.
Well, it's all part of the same. Maybe if you can restate your question, I'm not sure.
Well, like if you have 3 different intended uses, and you're not sure if one of them is going to go south and the other one's not, and you want to be able to go right to market with ones that are not infringing. And if your opponents are right about the one takes the whole thing down, the one that's infringing makes the whole ANDA invalid, then it seems like next time would you have separate ANDAs and sort of bring them together as like joinder of claims, and not have that problem. And I take it that the answer is, well, first of all, you would want them to be the same case. You would want them to go at the same time. You're using largely the same evidence.
Right.
And so it's a strange formalism to require that.
Yes.
To be, and it's not even really, contemplated.
That's exactly right.
But conceptually, that's exactly what you say, how you should be treated, which is that you have 1 infringing, 2 non-infringing intended uses, and you should be able to proceed in some way. And you're looking for the way to proceed promptly with the non-infringing.
Right. I mean, the statute wants you to file the broadest possible you can, right? And that's why and then so you challenge, or you subject yourself to challenge on everything. And then specifically with method of use patents, I mean, right, method of use patents are treated entirely different under the statutory scheme, in that you are then allowed to say, okay, I'm going to carve that out, right? I mean, carve outs are an absolutely critical portion of how the generic industry operates, and that's exactly what we did here. I'll just say in closing, our interpretation of this order is the only one that harmonizes everything in this case. It harmonizes how the Federal Circuit described the Patent Act is meant to operate. It harmonizes with how the enabling statute of FDA tells it to read patent orders, and it harmonizes with FDA's regulation. FDA's interpretation of it is completely at war with all of those.
Did Salix have an opportunity to challenge the amended ANDA at trial in Delaware?
So in the previous patent litigation, did it challenge? No, I mean, that's what we were arguing about before the district court litigation. So if Salix truly believed that application was now infringing, it could file a second patent litigation against us. But this is the key. It doesn't believe it's all made up. They do not believe it's truly infringing. And we know that because they did not sue us on that basis on the 370 application, which is the exact same now drug.
So the ones that were found, the intended uses that were found non-infringing in the District of Delaware litigation, there's a little bit of unclarity in my view in the briefing there, where they were not stipulated. They were subject to trial. Those, and they're the IBSD.
So
and the was it the formulation? Polymorph.
Yeah.
Those were not stipulated to be non-infringing, but they were held to be non-infringing.
So I want to be absolutely accurate. And if you look at the, I think it is the FDA's second forfeiture memo in the record, and I can get you it's in the other case, but I can get you the citation, and also the tentative approval in this case, which is JA 335. It goes through the patents. So there were final judgments on one of the polymorph patents and I think a couple of the IBSD patents, because those were their best patents. And then there for other patents that also were related to that, there were stipulations of non-infringement. So basically what happened in the Delaware court is they tried their best patents, and we prevailed on those patents, except for HE, which the statute allows us to carve out, and we did.
I think the answer to this next question is no, but if we were to rule for you in the next case, would that moot this case?
No, it wouldn't moot that case. And for part of the reasons that I'm talking about is Salix says it has unique defenses. It would, basically sue for a TRO to say that FDA validated the 30-month stay decision, even though they've already addressed. I could see, depending on how broadly you rule for us in 370, it might, not in a legal sense, but it might make the 369 appeal less important. But there's a whole bunch of different moving puzzle pieces here at the same time,
And
which is
how much of, I was wondering that about the 180-day exclusivity in 370. If you were to prevail here, wouldn't that, you'd have to confront that here too?
So if we prevail in this case, the patent-related hurdle is clear. We're eligible for immediate approval. FDA would need to confront the 180-day exclusivity issue, which is the exact issue in 370. And so, I mean, that's why we're pushing both at the same time, because if we just took 370 off the table, we would just be back here in a year, and we would need to go through all these really complicated statutory provisions.
So if that's the same in both, I guess I'm sort of trying to absorb the answer that you had to Judge Walker's question. Is there only that 30-month stay would not be applicable here, but would be applicable there?
FDA concluded in the other appeal that the 30-month stay is inapplicable in that case. Salix, however, contends that FDA erred about that and has indicated an intent to sue FDA about it. But it can't
raise that here.
It can't. I mean, I think it did raise it in its reply brief, but it's just not before the court because their claims aren't ripe until FDA grants final approval. Thank you, Your Honors. I appreciate it.
Morning, Mr. Schoenfeld.
Mr. Day for this case.
Thank you. Thank you.
Yeah, of course.
Funny, the two cases sort of look alike.
Good morning, Your Honors. May it please the court. Hayne Day for the government. Norwich's position that it was confused about the meaning of the Delaware court judgment cannot be squared with the Delaware record. That judgment, Norwich asked for a judgment that was narrow, that would have allowed it to carve out the HE indication and seek immediate approval from FDA. The district court refused to do that because it would not prejudge infringement questions about that carved out ANDA. It instead adopted Salix's proposed language. Everyone, Norwich included, understood that judgment to bar even amended versions of Norwich's ANDA. As Norwich put it, it operated as a, quote, absolute prohibition on FDA's approval of Norwich's amended ANDA. That's on JA 83.
But why? That doesn't make sense. Given what Mr. Prince was just arguing, if they'd gone to trial and the court has found that two indications are not infringing, what is gained by treating the way those non-infringing indications were packaged together in the ANDA with one that was found infringing? What is gained by having the infringement finding with respect here to hepatic encephalopathy prevent going to market quickly on a non-infringing indication? I don't really follow that.
Yeah, I think there are good reasons, but before I get there, I want to make clear that whether or not there are good reasons, that's not really before the court. That's a question about the validity of the judgment.
The statute that you're defending and the logic of it.
Yeah, and I think there are good reasons given the litigation strategy. And talking about, Judge Pillard, the questions you asked about what reached final judgment, what reached settlement, that's sort of indicative here as well, because the patent litigation involves narrowing your claims. Salix had to choose to narrow its claims to come down to specific indications, and that's based on the ANDA that Norwich had filed at that point. Had Norwich done a prejudgment carve-out, as the case law recognizes as appropriate, it could have focused on different claims and presented different arguments. So I think that's one reason it makes sense.
But
If it had done
go ahead.
You-
Go ahead.
If it had done a prejudgment carve-out, the validity and infringement of those other patents wouldn't have been litigated. And that's exactly what the Act wants. Doesn't it want broad ANDAs, full patent litigation to clear out bad patent litigation, bad patents, and then for the drug to come to market in a non-infringing way, rather than this other rule would effectively just penalize them for filing a broad ANDA and going through the patent litigation as to all of them instead of just a subset.
So I agree that is one purpose of the statutory scheme here. Another is protecting patent holders' rights. So that's sort of the counterbalance here when you're narrowing interests. But I would like to step back and say that this case is not about whether it was appropriate or correct for the judgment to be entered in the way it is. It's only about the plain language of the judgment. Before
those arguments, as Judge Pillard said, you agree that your position or what's happened here is impossible to reconcile with the regulation about what's supposed to happen after a finding of infringement, right?
No, I disagree with that. So I think that question is separate, as a separate issue does not need to be reached, but also it's not the timing rules that govern when FDA can approve. It's fundamentally the order that the court entered, right? So those timing rules define internal FDA operations. The Federal Circuit has held this expressly in Ortho McNeil. It reaffirmed it recently in Vanda. That's how the Federal Circuit has read these provisions, and had Norwich wanted.
That's how they read it. What are you referring to?
That's how the Federal Circuit has read the FDCA in relation with 271E4.
That being
the decision in Ortho McNeil. Ortho McNeil decided that the timing rules in the FDA Act, the FDCA, do not serve to limit district court's authority to enter resetting orders outside the bounds of those timing orders. And because of that, the question here is only whether the district court intended its decision to bind even amended versions of the ANDA. And I think on the Delaware record here, that is clear because
what about if we read it? I mean, I thought that Norwich is reading it, that it's saying we are not addressing that. And they feared that it might be read to be addressing their amended ANDA, but they were told that wasn't before District of Delaware. We're not going to sort of, after the fact, pretend we've litigated something that we haven't, said the District of Delaware, not really, having before it to think through the implications of that. But then when they come to the FDA and say, okay, you can look at that record in the District of Delaware and you can look at whether these were stipulated or not stipulated. And if it's true, as Mr. Prince was saying, that Salix brought forward its strongest versions of these various claims, then is it troubling that they, which ones they stipulated away and which not? I mean, why can't the FDA look at that and say, great, we want to get generics out if they're non-infringing, and we're confident on this record that the indications that were held to be non-infringing, that there's not any cloud on that the merits of that determination. So sure, we accept the amended. And what's not right about that?
I think there are a couple of responses. One, FDA serves a purely ministerial role. Its job is not to dig through the record and assess whether patent infringement would occur on the amended ANDA. That, under the statutory structure, is a question for district courts, not the FDA. So I think that's the first response. And second, I think that the record just doesn't bear out that Norwich feared the judgment operated as it did and tried to argue around it. I think fundamentally Norwich asked to modify the judgment, did not ask for clarification about whether that judgment actually didn't bar amended versions of the ANDA. It filed a Rule 60 motion saying it was inequitable for it to continue barring amended versions of the ANDA.
So I agree. The best support for what the FDA did here is the statements in Norwich's Rule 60 motion, and then it's briefed to the Federal Circuit, right? Saying, for example, please remove the absolute prohibition on approving our amended ANDA. And that may be a powerful point. It is the extremely odd feature that the case would be entirely different if they had started that motion by saying, we don't think your judgment bars our amended ANDA, but in an abundance of caution, and as any prudent lawyer would do in this situation, we are asking you to clarify that it doesn't bar our amended ANDA. And it's a little strange if the whole case turns on that.
I don't think the whole case turns on that. I think it is the relationship between what they filed in contesting the judgment and what they filed in the Rule 60 motion, and then what the district court actually did. So I think it's key to focus on what the dispute was. So when there was a dispute about the judgment, Salix wanted a judgment that barred ANDA 214.369, period. Norwich wanted one that would allow carve-outs of the HE indication. The district court adopted Salix's version. When there's a dispute at the Rule 60 stage, Norwich said, we want to modify that. We think that's wrong. We want an approval for an amended ANDA. The district court rejected that, and the Federal Circuit affirmed it. So I think it's the combination of the two, not just magic words in the motions specifically.
I know I've asked this before, but can you explain why the statute and the regulations would require that, given that, as Judge Garcia was asking, and assuming one would want a ambitious ANDA to clarify validity of patents, which are anti-competitive and limit the market. But you don't want to make that carry this downside risk of huge amounts of money and huge amounts of time if you overshoot, and as in this case, have one infringing indication. Like dropping the correct way in FDA's understanding of its statute and regulations to drop the infringing intended use and proceed with a non-infringing label is to go back and start over?
So I want to make our position really clear on this point because I don't think the statute and regulations require the district court judgment necessarily to have entered an order that would bar even amended versions of the ANDA, either at the judgment stage or at the amended stage. So it's not a complete, requirement of the statute. Just that the district court did.
Do they even authorize it?
Yeah, it's within the district court's discretion at that point, at least once the judgment is entered, right? So on the facts of this case, you have a post-judgment amendment. And this is what the Federal Circuit has said in its Faring decision, that after the judgment, the court has discretion to consider whether to amend that judgment in light of an amendment to the ANDA. And that's what happened here. That's the direct avenue on direct appeal. The district court declined to do so and reaffirmed that its original judgment barred even the amended ANDA, and the Federal Circuit affirmed.
And why does it have authority to do that?
Through the Patent Act, 271E4A provides it authority to reset the deadlines for ANDAs. If there are no further questions, we'd ask that the court affirm.
Killian.
Good morning, Your Honors. May it please the court. Brian Killian for Salix. I think underneath many of the court's questions here has been, I'll call it an assumption, which I think fed by Norwich, that the question of whether the amended ANDA truly does no longer infringes is kind of an obvious answer. We strongly disagree, but I don't think you need to take our word for it because Judge Andrews was presented with this very question in connection with the Rule 60b-5 motion to deem the judgment satisfied. The way the statute works is that once you get the infringement finding under paragraph 3, basically Romanet 3, if you've made a paragraph 4 certification, and then if the patent holder brings the lawsuit, then there's this complicated decision tree. And at the end of each of the points on that decision tree, it's of whether there's been a finding of infringement or a finding of non-infringement. They got a finding of infringement. They were then amended. And under the regulations, they're allowed to submit that amendment, but it doesn't automatically control the timing of the effectiveness. So they went back to Judge Andrews and said, we've now submitted an amendment. Please change your judgment. Deem the judgment satisfied. And he declined. And part of the reason he declined, Your Honors, this is on JA 331. This is his reconsideration decision. I'm just going to read a sentence. It is not a simple matter to determine whether an ANDA applicant has successfully carved out language from a label to turn infringement into non-infringement. The defendant, that is Norwich, other than saying it has successfully carved out the HE indication and providing me the label, has presented no evidence in support of its assertion. In other words, in this case, we came into court with well over 25 patents. And according to Judge Andrews, we were not going to get to try all of those. And so
I'm sorry. I thought your position was that you were not challenging the substance of the Delaware District Court determinations that the two uses are in fact not infringing. I thought that was
because, Your Honor, I don't believe we think that's actually what Judge Andrews held. What Judge Andrews held was he considered 8 patents and he found infringement as to the IBS, the HE, and validity as to those HE patents. And then he found infringement but invalidity as to the tried IBSD patents. But there were almost 20 patents that we didn't get to try. And we put them into a stipulation. We stipulated to non-infringement.
So put it another way, that you're not challenging the 370 ANDA on the ground that the indications are infringing.
I'm not sure I follow with the 370 ANDA question.
That they're not infringing the patents that were found non-infringing in the 369.
In the 370 case, which is in its early stages in New Jersey, we are suing over patents that are applicable to the 370 ANDA, and there's no HE patents in that. So the HE case, HE patents, no HE patents are
right.
asserted in that case.
Right.
But in the
so the footprint of it is parallel to the attempted amended ANDA in the 369, right?
Mm-hmm.
And you're not in the 370 challenging the intended uses
Oh, we are. That is
as
what
infringing.
we are. That is the 370 case. We're challenging that it's violating our IBSD patents in the 370 case. It's a different set of patents that were then tried in the 369 case. But this gets to my point, Judge Pollard, that we only were able to
So
try.
it's challenging them because as different patents from the ones that were found
Right,
non-infringing.
but to the same use,
369.
which is why when Your Honor asked the question about one use or another use, I think that slightly oversimplifies it
Right,
because
there are
of the
various patents
bingo.
to the same
There's
indication.
a lot of patents for each of the indications. And so, yes, Judge Garcia.
I hesitate to cut you off, but just so, I think you've already said that, is your point that if during trial they had disclaimed the HE use, you may have asserted additional IBSD patents in that
Have been a
litigation?
completely different trial, yes. We only had 20 hours to present our case, and we had to dedicate a substantial portion of that time to our HE patents. If they had carved out before trial, we would have been able to focus those 20 hours on IBSD.
So if we did
patents.
have the assumption that you started with, that
It was-
what's the big deal? There was a final determination that only HE use infringes, and you just have to disclaim that use and you can go to market. Your point is
That is
that's
not
unfair.
obvious at all,
It's
correct.
not, but it's not that it's not obvious as to the HE use. It's not obvious
To
as
the other
to
use, correct.
the other use.
Correct. And I'll note to the court, when we appealed this issue to the federal circuit, we only persuaded one judge that we had put on sufficient evidence to the validity of the IBSD patents. And it is our view that if we had not had to spend so much time and trial resources on the HE, I think we could have got at least one more judge in the federal circuit and maybe Judge Andrews himself. The point is, these decisions have substantial repercussions. And so that's why the FDCA, the Act, puts the patent judge as the one to decide whether or not a post-trial carve-out truly cures the infringement. In the Faring case, which we've
Are
discussed.
there cases, I'm sorry, please go ahead.
Yeah, no, the Faring case, I think I was just going to use as an example, Judge Garcia, if I'm anticipating your question. In that case, the ANDA applicant had brought up at trial, and the judge, in fact, discussed at trial the possibility of a carve-out. And they were able, therefore, during the trial to litigate the question of whether, well, it wasn't a carve-out, but removing the formulation, changing the formulation, whether that would then leave an infringing patent or infringing ANDA, or whether it be a non-infringing ANDA. The point is, there was trial time, and the patent holder had its rights vindicated because it was timely raised.
I hear that you're making an argument about sort of resources and the limitations of the patent court you can't litigate everything and you don't litigate everything. You litigate your top priorities, and those priorities may shift. But it does seem different, and this is, Norwich's argument that in Faring, if it's a formulation that's an issue, that it doesn't have this sort of what I think of as this modular quality of the different patents with the different indications. You're not like coming up with something that you're not changing the formulation.
I understand there's a technical difference between
Yeah.
carving out a use and changing the formulation.
Yeah.
But the upshot is the patent holder in either case has advance notice of what the target is, and then could put on the best case that it has available at the time.
Are there
And so,
cases-
as I said, I do want to clarify, Judge Pollard, because this is not a simple matter of just whether the carve-out cures the infringement, because there were all those non-litigated IBSD and polymorph patents in the stipulation. And as we pointed out, the footnote in the stipulation very clearly says that my client will agree to a non-infringement finding, but only if the conditions of use are not amended. That's actually a paraphrase. But the point is, it was a game time
Were
decision.
the conditions of use amended?
The indications of use, I'm sorry, indications.
Well, were the indications of use amended with respect to the patents that they're now, on which they're now seeking to go, the patented uses, indications as to which they're seeking to go to market, those haven't changed.
I don't fully follow Your Honor's question, but I'll try my best to answer it, which is to say,
You are, but
that by carving out the HE, right?
right.
There is now just the IBSD indication, and the trial in the 370 case in New Jersey is only focused on the IBSD indication.
But the indications with respect to IBSD haven't changed.
Well, that is the IBSD is the indication. So that's what I'm.
But so you said, say it again, I know this is all terms of art, that the stipulation was limited to circumstances in which what didn't change?
The indications.
Okay, so the indications for the subject patents didn't change. The indications for the surviving
The ANDA,
ones
so-
that are in the amended ANDA, those are the same as the indications that were litigated as to those patents that were litigated in the District of Delaware. So it's not saying,
Well, no, because the patents in the stipulation weren't litigated. I think that's, and I'm sorry if I'm not fully
Oh, right,
understanding, right? This is the
Right.
19 patents that we didn't have any time to
Right.
litigate, and we said, fine, we'll give you a non-infringement finding. But this is a recognition of the fact that we didn't get to litigate it because you
didn't
put
get
on
to
a
litigate them, but the ones that they're wanting to go to market on, you did get to litigate.
We got to litigate a handful. That's correct. Not all. Because let me be clear. In the stipulation, Your Honor, it covers HE patents, IBSD patents, and polymorph patents, right?
Right.
So each of the types of patents, there were some that were litigated and some that were not litigated. And so
And
it wasn't.
your claim is that it's to the extent that Norwich is saying, we don't want to infringe any of those stipulated patents. We're just going to we just want to go to market for the indicated uses on IBSD and polymorph that we won. If that were their position, what is the argument that the deprioritized stipulated indications are somehow an obstacle?
Well, so this was presented to Judge Andrews in the reconsideration motion, and he's the one who said in that quote that I won't reread to the court that it is not a simple matter to make the determination because as we presented to him, we didn't get to litigate a bunch of our IBSD and polymorph patents during the trial, and the stipulation that we entered into and that he so ordered recognizes that it was a
Right.
conditional stipulation.
Right. So I imagine Mr. Prinz would also say smarter things, but one thing that occurs to me is that he might say, you're saying we had to not litigate certain IBSD patents. Number one, that means you made a judgment during trial. Those were not your strongest patents. You litigated the
Disagree
strongest
with that,
ones,
but
and you lost. And also, if you think they're strong, sue us on the amended ANDA. Initiate a litigation to
And the
stop.
reason we haven't brought that lawsuit is because, as Judge Andrews has held, the amended ANDA is not approvable until October 2029. And so in other words, and that was the longest lived patent that we litigated. And so, Your Honor, there's really no fight over that we could really bring right now for whether the amended ANDA infringed those, because as the judgment pertains to the amended ANDA, it's not approvable during the lifetime of any of the patents.
But that is a bit circular because we're questioning, I think, why that is.
Why?
Why they have that later date.
Right. So they had that later date because when they lost at trial on the HE patents, that was the October 2029 was the expiration of the longest lived of the HE patents that they were found to infringe and that were deemed valid. And that patent, I understand, had a longer expiration date than any other patent that was at issue in our complaint. And so as long as that judgment blocks, there's no suit for us to bring to challenge the amended ANDA, because by the time that's approved in 2029, the other patents that we didn't get to litigate will have expired. So I don't believe that it's circular.
Yeah, my
Your Honor, but I
question
believe-
was counterfactual, where Norwich has the right reading of the judgment, and what would happen in the world is you would go ahead, but I understand your question.
Sure, and that's the reason why Judge Andrews is the one in charge of making these determinations, because he'll have already seen, have we had our chance to litigate these questions? Did it come up at trial? And if he says,
Judge Andrews is supposed to essentially, in your view of how this scheme would work, is to weigh the unfairness and the notice and all the various interests and
Exactly. As the
decide
Federal
whether
Circuit
to
held.
carve out the amended judgment, other amended ANDAs.
That's exactly right. He's the one who heard the trial. He knows whether it's obvious or not that the carve-out cures infringement. He knows that the parties made strategic decisions. He evaluates the equity. He evaluates the fairness. As Your Honors noted, Norwich did appeal the Rule 60B5 determination, and the Federal Circuit unanimously affirmed that. And so those decisions, we think, are consistent with the statute. They're certainly protective of our patent rights. I've gone well over my time. I'm happy to address other questions, but
I think this is a friendly question to the extent it makes any sense. don't know if you've ever been to a basketball game at halftime and they have a competition for a fan. You get to shoot a free throw, a 3-pointer, and a half court. You can make all three. So I'm imagining that you have, I'm just going to simplify, but 3 HE patents and 3 IBS patents. And your odds of prevailing on each of those patents differ from each other. One might be the odds of making a free throw, one might be the odds of making a 3-pointer, and one might be the odds of making a half-court shot. And the judge here said, all those 6 patents, like you get 2. You get to take 2 shots. And so you took your free throw for the HE and your free throw for the IBS.
Yep.
And you hit your free throw for the HE and you missed your free throw for the IBS. But if they had carved out the HE to begin with, you could have taken the free throw for the IBS and the 3-pointer for the IBS. You may well have made the 3-pointer for the IBS.
With the additional nuance, Judge Walker, that it's not just simply taking a shot. It's the amount of time it takes to win. So hypothetically, our best HE patent may need 10 trial hours. And if you only have 20 trial hours, you have to make these trade-offs. It may be that the 2 best patents are each 10 hours each, and that it's just a better judgment to litigate 9 patents that each only need an hour and a half because of the way the court has set the top. Those are strategic decisions that we're not here to second guess and relitigate, but that Judge Andrews was the one who superintended. And that's why we believe that his decision was correct. That's not the question. Why FDA's decision to make the effective date in accordance with this decision is correct. I'd be happy to address the statutory arguments that we raised as well, the regulations, but if the court would like me to sit down, I'll do that too.
All right.
Okay, thank you, Your Honors.
Thank you. Mr. Prince, we hear you, your rebuttal on this appeal.
Thank you, Your Honor. Maybe I'll start with FDA first and then move on to the intervener. FDA was sort of acting like this depends on what we were fighting about prior to the judgment and what happened in the Rule 60 proceedings. But I don't think that's the actual logic of its rationale. I don't think it's saying there's something specific about this case. The tentative approval decision just notes it's set the date. So it's not clear to me FDA is doing a one-off specific interpretation because of this judgment, or it's just interpreting these kind of judgments incorrectly all the time. But if it's interpreting this way all the time, that's certainly not how the statute is meant to work. Salix keep saying that they made strategic choices and all that, but these patents are not completely distinct patent, right? They're all fairly similar patents. They chose their best patents to litigate, and the stipulation they're talking about was after the case was tried, right? So they picked their best patents and they litigated it. Yes, Judge Andrews did put some restrictions on the trial time, and most judges do that, and that's just part of trial. It doesn't mean we should distort how the entire statutory scheme operates because of that. If they could have asked Judge Andrews for more time if they really thought that was going to be the issue. But more fundamentally, the Patent Act gives us the solution to all of these problems. If Salix truly believes there's still infringement, it will be able to sue us again for patent infringement. If it believes that we violated the stipulation in that case by amending the ANDA, it can sue us for patent infringement. But it's not going to do that because it knows there's no infringement. And again, I just want to say this again. We know that from the 370 case because they did not assert these patents against us when they sued us about the 370 case. So this idea that there's some hidden infringement from their HE patents that reads over to IBSD is a complete fiction, right? Or they would have asserted those arguments in their 370 case. And I think my friend was also conflating what they're doing in the 370 case. They're suing us on IBSD patents in the 370 case, but that has nothing to do with the patents that were at issue in 369. Those were later listed patents. They didn't exist at the time. So if it had claims on the patents that were litigated in 369 and it was unfairly deprived of the ability to litigate, as it says, it would be asserting those in 370 now, and it's not.
I'm good.
Thank you.
All right, the case is submitted.
Case number 25-5137, Norwich Pharmaceuticals, Inc., appellate versus Robert F. Kennedy Jr. in his official capacity as Secretary of Health and Human Services et al. Mr. Prince for the appellants, Mr. Schoenfeld for the federal appellees, Mr. Killian for the appellee Silence Pharmaceuticals, Inc., and Mr. Burgess for appellee Teva Pharmaceuticals USA, Inc.
Morning, Your Honors. Good to see you again. As we've been discussing, Norwich has spent more than 5 years trying to bring this generic to market, including by securing patent court judgments that none of the uses for which it is seeking approval in this other ANDA that everybody told us we should file are protected by valid patents. But FDA has refused to approve this one because of a so-called 180-day exclusivity held by a different generic manufacturer, Actavis, who settled its patent litigation, unlike us, and agreed to remain off the market for a decade. According to FDA, that forecloses the entire generic market in the meantime, even for unpatented uses of the drug. FDA misapplied the statute and should have concluded that Actavis forfeited its exclusivity on 2 different grounds. And the consequences of this, just so you know, are pretty severe. A 14-day course treatment of this drug for IBS-D is $3,000. So if you agree with us in this case, we would respectfully request that you do so quickly and issue the mandate forthwith so we can fix this problem, which we're prepared to do right away. Unless the court has a different preference, I plan to start with actually the second issue in our brief, the failure to obtain tentative approval issue, because I think it's the most straightforward opinion you could write in our favor. Actavis forfeited the 180-day exclusivity by failing to obtain tentative approval within 30 months. There's a single exception to that bright line forfeiture rule, which is if the failure is caused by a change in or review of the requirements for approval. FDA excused that forfeiture because in March 2017, it required sponsors to conduct comparative dissolution testing and was still reviewing the results of that as of the June 18 date. But that was error because they simply applied the wrong legal standard. The correct one is the default one, which is but for causation. And under that standard, nobody contends that we're wrong that there was a forfeiture. And for good reason, because as Bostock instructs, to determine if comparative dissolution testing is the but-for cause of the failure to obtain tentative approval, you just remove it from the occasion, you just remove it from the factual world and see whether the same result would have occurred. And the answer here is obviously yes, because Actavis's application was deficient from the moment it was filed and remained deficient for years after the deadline. The record clearly shows that there were 2 unrelated deficiencies that prevented approval, specifically serious quality deficiencies with the drug and a missing clinical endpoint study that FDA had required sponsors to conduct as early as 2012. And I believe that's undisputed. The information is under seal, so I don't want to go too much into the—
Mr. Prince, I think I might be on board with the argument you're making. There's a part of it that gives me some pause, and that is the possibility that there is going to be an effect with no cause. Because it seems like the deficient application was alone enough to doom success within 30 months.
Yes.
But if the application had been perfect, it seems like the FDA's change in requirements was alone enough to doom approval within 30 months. That's at least kind of assumed for the sake of this argument. Is that right?
Yes. So there are basically multiple sufficient causes.
Right. And so you're saying, well, the change in requirements wasn't the cause because there's another sufficient cause. But of course, the same thing could be said for the deficiencies in the application, that we could say they're not the cause because the change in requirements was sufficient to be a cause. So if if the change in requirements are not a cause, it seems like the deficient application should not be a cause either for the same reasons. And now you're left with an effect, failure of the application that has no cause.
Well, I have a few answers to that, Your Honor. First of all, the exception to but-for causation for multiple sufficient causes is not itself the federal default. I mean, that's the Supreme Court's debate in the Nassar case between the majority and the minority, and FDA's view that this is somehow a multiple sufficient cause case lost. But I'll just take it on its own terms, okay? They're applying the multiple sufficient cause requirement in the back, they're applying it upside down. They're applying it backwards. The context here is critical. And as Nassar explains, you need to understand the context to apply a multiple sufficient cause analysis. This is a forfeiture provision, right? It is Congress added it to prevent the problem of first applicants like filing deficient applications and then bottlenecking the approval of other applicants while they take years to actually do the work to actually get the approval process. FDA correctly recognizes at JA 580 that Congress's purpose was to prevent first applicants that do not meet the substantive requirements for approval from delaying other ANDAs. So the general rule, which FDA describes elsewhere as a bright line rule, is harsh. You've got 30 months or you're done. And that applies, by the way, even if FDA is just being really slow. The clause we're talking about is a limited exception to that harsh rule because Congress did not want to penalize good faith manufacturers who had good applications for situations outside their control. Under FDA's standard, a manufacturer with a blatantly deficient application gets a get out of jail free card just because by happenstance, FDA changed a review requirement that even if that never happened, never would have made a difference for their application. And that's not what if that's the standard, FDA needs to identify textual or contextual support for it. And there's absolutely no such support for that here. In fact, all the support cuts exactly the wrong way.
Does it matter?
I was just going to say that given the potential multiplicity of causes, wouldn't the presumption go the other way that if they meant it to be but for cause, you would expect them to have so said in Congress to have so said?
I don't think so at all. I mean, Congress used the word caused by, which the Supreme Court in Barrage has specifically said means but for causation. My friends say that Barrage interpreted results from, and that's true enough, but it specifically equated in the opinion itself results from to caused by. I mean, it literally drew the comparison. And so the default presumption is but for causation unless they can show contextual or textual support that some other rule applies. Their other argument is that that's limited to the tort and criminal context, but that's also not true because this court, including in an opinion that you joined the panel on, Judge Pillard and Sinclair v. EPA, has applied it in the context of reviewing an agency's interpretation of its enabling statute. So the burden is on them to demonstrate the standard is different, and they've come nowhere close to showing that Congress would have intended some sort of get out of jail free card for deficient applicants. It doesn't really make any sense.
I suspect, at least in the briefs, the main case the other side is citing is Kilburn. And I wonder if you would
Sure. So
to explain why the context there might be different.
So there's a lot of things I can say about Kilburn. So Kilburn was decided a decade before Barrage, so I'll note that, where again in Barrage, the Supreme Court explained what the ordinary meaning of cause is. So this court didn't have the benefit of that. But that's also the context in that statute is, for example, one of the reasons why you would sometimes apply an exception to but for causation. It was a jurisdictional statute, essentially trying to sweep within it terrorist-related activities, and the court declined to apply but for causation because it said it would be inconsistent with the structure of the statute in multiple ways, including that the statute substantively penalized material support for terrorism, which sort of indicates if all you need to do is provide material support to be liable, it indicates that Congress might not want to but for cause. But the other point it noted in that opinion was that because it's just a jurisdictional statute, it makes sense for it to sweep broadly because the underlying causes of action have their own causation requirements that could sweep more narrowly. So it makes sense to be more over-inclusive in that context. There's cases subsequent to Kilburn, by the way, including Owens. First of all, what Kilburn said is proximate causation was the standard there, but my friends are not applying proximate causation. They're not even applying that standard. They're applying a caused in part by standard, which appears, as far as I can tell, to be completely plucked out of thin air. It's not even a normal causation standard. The Department of Justice, in its brief, has attempted to reframe it, Judge Walker, kind of how you were thinking about it, as a multiple sufficient cause sort of standard. They probably have a Chenery problem there, but whatever, I don't want to press that. But that argument doesn't work for the same reason I said before, which is they're applying it backwards. When multiple sufficient causes applies, it operates to punish sufficient wrongful conduct, even when there's innocent conduct or even perhaps multiple wrongful conducts. That's when you apply that to impose, to prevent a wrongdoer from escaping liability. Here, they're literally applying it upside down to excuse the wrongdoer, right? And that's the distinction. If there's no more question on that, I do want to make sure I can get to our failure to market claim. And this part of the statute is admittedly notoriously complex, but our basic point is simple, and that's that a first applicant forfeits its exclusivity by failing to timely come to market when another generic demonstrates that it's possible to obtain immediate approval for unpatented uses of the drug. The text, structure, and history of the statute foreclose FDA's position that 180-day exclusivity confers on a first applicant a right to exclude that is far broader than the brand holder's patents themselves allow, allowing here the first applicant to exclude all uses of the drug, even unpatented uses, for a decade. And again, this relates to the separate issue in that FDA is just ignoring the structure of the statute. To determine a generic's approval date, the statute applies a series of timing rules to each certification made by the generic and calculates a date associated with each and uses the last applicable date. Timing rule 4 is what causes the 180-day delay, and it applies only when a first and subsequent applicant have made a paragraph 4 certification to the same patent. We explained at length in our brief why that has to be right, and I'm happy to answer questions about it, but
So one of the reasons that maybe the FDA's view has to be right is that it seems like under your rule, because forfeiture, take as given for the moment that the statute does not allow a limited one-off forfeiture as to one subsequent applicant. The consequence of your position would be that if the first applicant, it would basically, it might make sense as to your application, but the consequence would be forfeiture as to all subsequent applicants. And that's the reason why when we ask what are the qualifying certifications, we have to look at the first applicant certifications.
so we have not taken a position on whether the forfeiture would apply to everybody else, but I'll just assume it will, because frankly, I think that probably is the better reading of the statute. I don't actually see why that's a problem for us, because what Congress is saying to the first applicant is when someone demonstrates that you can launch, you can't just sit on your hands. You need to launch.
But wouldn't that mean if there was, the first applicant says, I want to use this drug for IBSD, not HE, and you come in and you say, I want to use it for HE, you would then have affected a forfeiture of their exclusivity period as to the IBSD use also. How does that make sense?
Well, not in that case, because we would have been certifying to different patents. So we wouldn't even be applying the timing rule in the first place. But But assume we did have a patent in common, right? Which I think gets to your hypothetical.
Yeah.
So we both had product patents. We certified to the HE, or we certified to IBSD, and they certified to HE. I think we would be able to launch in that circumstance.
And then everyone else can launch as to IBSD.
Potentially that could be correct. But that situation itself is going to be extremely rare, where the first applicant would have one product patent and one method of use patent. We would have a product patent and then an entirely different method of use patent. I'm not aware of any circumstance where that's ever occurred. If you believe us that the statute requires matching certifications, which again FDA does not fight us on appeal, and they interpreted the same language the same way, which Congress reenacted, I think the rest of our argument just falls naturally into place. The statute, when it's determining whether there is a forfeiture event under BB, is asking what are the certifications qualifying the first applicant for the 180-day exclusivity period. They argue that it has to be the certifications qualifying the first applicant as the first applicant, but that's not at all what Congress said. It said qualifying the first applicant for the 180-day exclusivity period. And the only place that you can look in the statute determines what qualifies you for the 180-day exclusivity period is the operational provision of Timing Rule 4 itself, again requiring matching certifications. FDA's view is just reading language out of the statute and wishing it away. I think we also win on very solid, our interpretation is also consistent with the purpose of the statute, right? I don't think anybody disputes that in 2003, Congress was trying to rein in the scope of exclusivity at that time when the statute operated, in some sense how we're saying it operates now, which is it blocks matching certifications. But the problem at that time was that Congress, FDA had interpreted the statute so there are multiple sequential periods of 180-day exclusivity. Congress fixed that, but it fixed it by defining the term first applicant and making one single period of exclusivity tied to when they market. It didn't change anything about this patent by patent approach. And the perverse result of what FDA is doing here is it's saying the forfeiture provision blocks more broadly than the timing rule itself, which doesn't really make any sense. And in fact, the scope of that exclusivity is way, way, way broader than it was prior to 2003, such that it's blocking unpatented uses of the drug. It makes no sense that Congress would have intended that.
Isn't that comparing apples and oranges? I'm not going to be able to aptly describe why, but the one is sequential, multiple sequential, and the other is to the extent there's a 180-day period, what's its scope? And that seems like those aren't necessarily inconsistent. If the prolongation shouldn't be available with respect to different indications of one drug, well, go ahead.
I agree, and that's the fundamental point. And this is where, if you're asking me what went wrong here, I mean, again, FDA agrees that under the 2003 version of the statute, as far as I can tell, we would prevail because it only blocks matching certifications. And what had happened at that time is FDA called its general approach to the statute, including matching certifications, including that there can be different periods of exclusivity. It called all of that patent-based exclusivity. And Congress, people complained about it. There were court decisions about it, and Congress changed it and said, we're no longer going to have patent-based exclusivity. We're instead going to have product-based exclusivity. This isn't in the statute. This is all informal industry lingo. And I think FDA said, oh, no more patent-based exclusivity. That means, the whole part of the statute requiring matching certifications no longer matters. But that's not what Congress was doing. Congress was shutting down the sequential periods of exclusivity.
But if it's patent-based, then doesn't that, or if it's relational, then don't you have different 180-day period? They can't extend past 180 days, but you have different exclusivities with respect to different.
There's a single period of exclusivity because that period is measured from the first 180 days of marketing. But this goes to the question you were asking before, which it goes to the scope, right? Because the exclusivities are still tied to specific patents, but they all start and stop at the same time. It's one period. So it's an issue of the scope of that exclusivity.
Why are you emphasizing this relational idea then?
Because that's how you know what the qualifying certifications are, right? This whole the idea that there's a first applicant, there's an exclusivity like in the abstract is not how the statute's structured, right? It's structured effectively as a computer algorithm. I mean, there's sort of an evil genius way to it about this. And it's running the 180-day exclusivity provision on each certification made in our application. Right? It's going to run it many, many times on an application.
Why isn't it running? I thought it was just running it on the drug.
No, so we have an application, right? The statute instructs FDA to look at each certification made in that application and apply a series of timing rules to it. The 180-day exclusivity is timing rule 4. And so it's going to apply that provision multiple times. It's going to apply it to every paragraph 4 certification we have made in our application to see if it's blocked, right? Everything is nested under a colon where the statute is specifically instructing FDA to apply it to each certification. FDA never responds to that. They just simply ignore it or act like Congress did it by accident. But Congress did it that way in 2003 when it amended this provision. So that's when it all happened. I hope I can persuade you if you look at the statute that's how it works.
This is where you have that chart in your brief and.
Yes.
Yeah.
Right. The statute literally says you apply the following rules to each certification made, all of our certifications. And that's why you know what the qualifying certifications are.
Thank you.
Thank you.
Good morning, and may it please the court. Gabriel Schoenfeld for the government. FDA applied the correct legal standards to determine that activists, a first applicant that qualified as eligible for exclusivity by submitting an ANDA for rifaximin 4 years faster than Norwich did, had not forfeited that eligibility, and that Norwich's subsequent application could not be approved as a result. It's worth emphasizing at the outset, Your Honors, what isn't in dispute today. There's no dispute that activist is a first applicant, and there's no dispute that so long as it remains eligible for exclusivity, that eligibility would operate to block Norwich from approval via the effectiveness of application provision that you were just discussing with my colleague a moment ago. And I think it's worth starting where my colleague ended with the failure to market forfeiture provision, Your Honors, because I recognize this is a complicated and articulated scheme, and I think I want to catch you. Please, Judge Puller.
Let me just ask you a threshold question. Has activist amended its ANDA to include paragraph 4 certifications to the new IBSD indication patents that Salix acquired that are the subject of the New Jersey case 912 and 571?
My understanding, Your Honors, is that the 370 ANDA does contain paragraph 4 certifications of those patents, which is why Salix has been able to bring that litigation in New Jersey over them.
And is that not relevant to the forfeiture analysis even under Norwich's theory? In other words, if activist shares paragraph 4 certifications to the same patents as Norwich's 370 ANDA, and they haven't experienced a forfeiture event because they're being actively litigated, is that an additional reason that a failure to market forfeiture has not occurred?
It's not, Your Honor, because the patents that qualify an applicant for exclusivity, that qualify it as a first applicant, are only the ones that it's certified to on day one, because these are later issued patents. They don't matter, but I think that this does get into an important distinction that Norwich's position is really built on eliding, which is the distinction between whether a first applicant is eligible for exclusivity, whether it has qualified for the single 180-day exclusivity period that is applicable as to all subsequent applicants, and whether that period, in fact, operates to block a subsequent applicant based on the specific contents of its subsequent ANDA. So the provision that you were just discussing with Mr. Prince about whether it contains such an application, it's true that that provision is applied on a certification by certification basis as to each subsequent applicant. The problem is that's not the provision of subparagraph B4 that says when a first applicant has qualified for exclusivity. And that's what forfeiture turns on. Forfeiture doesn't turn on the contents of a subsequent applicant's ANDA, which might affect the scope of the exclusivity's blocking effect, you might say.
Reveal its scope? Does it affect its scope or does it just reveal its?
I think the fairest way to read the statute, Your Honor, is that it is a matter of revealing the scope, or it is a matter of the scope of the eligibility's blocking effect as to a specific ANDA, rather than whether the eligibility exists as a threshold matter. Remember, Your Honor, that the relevant statutory language talks about the patents that are qualifying for the 180-day exclusivity period. And the 180-day exclusivity period is a defined term in the statute. You can find it on page 12 of the addendum to the government's brief. This is at Roman 2 under subparagraph 4. The 180-day exclusivity period is defined in generic terms. It's not defined in terms that vary based on the contents of a subsequent applicant's ANDA. It's the 180-day period, the ending on the day before the date on which an application submitted by an applicant other than a first applicant could become effective. So the qualification, rather the existence of a 180-day exclusivity period, doesn't depend on the existence of a subsequent ANDA. The period exists whether a subsequent ANDA asks FDA to consider whether that period is blocking or not. And that definition of the 180-day exclusivity period only contains one qualification, one precedent requirement that has to be satisfied in order for that period to come into existence, and that's being a first applicant. The qualifications for being a first applicant, I think nobody disputes here, are then set out in subsection BB, also under Roman 2 of subparagraph B4, and it explains that it's submitting a substantially complete ANDA that contains paragraph 4 certifications on the first day.
Do you agree if there was no matching certification at all between the first applicant and Norwich, they just wouldn't be blocked?
That's correct,
the
Your Honor.
FDA's position. Okay.
But the reason that's not an issue here, and the reason that FDA didn't reach the question of whether such a certification post-2003 requires matching certifications, is because everybody agrees there are 4 matching certifications. That's 1 to the IBSD patent. And I
So maybe more accurately, the FDA hasn't taken a position on that question.
That's correct.
Because this case doesn't present it.
Exactly. And that's why we believe that this court should likewise not reach the question of whether such a certification requires matching certifications. And if the court doesn't have any additional questions on yes, Judge Pillar.
Finish your sentence. I'm sorry.
If the court doesn't have any additional questions on failure to market, I'm happy to address failure to obtain tentative approval as well.
Yeah, go ahead.
So first, I want to emphasize at the outset, Your Honors, that FDA does not concede that there would be a forfeiture under the but-for cause standard that Norwich proposes, or under any other causal standard this court might see fit to instruct FDA to use. The standard remedy for when an administrative agency applies the wrong legal standard would apply here, just like in any other case. The court would inform the agency the way in which the standard applied was wrong. It would remand for reconsideration of this, I think, complicated factual question if it's a but-for cause standard under the appropriate standard. But more importantly, Your Honor, FDA's...
And why would there be a need for a remand? And maybe I can ask it this way. If there had never been a change in the FDA requirements or rules post-application, according to you, we don't know whether activists' deficient application would have been corrected and then approved before the 30-month deadline.
That's exactly right, Your Honor. I think this gets to a real problem with the but-for cause standard that Norwich is urging this court to adopt, which is that it would require the agency to construct a completely impenetrable hypothetical counterfactual world of if FDA had not asked the applicant to invest additional resources in addressing this change to a requirement, how would that have played out both before and frankly after the 30-month date? Because, for example, what if there was an inspection that in the real world happened after the 30-month
And that
date.
may be a downside of their tests. If we're going to like talk about downsides, it seems like a downside to your test is it gives activists a get out of jail free card for forever.
I don't think that's the right way to frame it, Your Honor. I think the way to understand it is that if there's one thing that Congress was clear on when it wrote this particular exception to the forfeiture provision, is that it wanted to ensure that applicants which were unable to obtain tentative approval as of the 30-month date through no fault of their own, or at least through no fault of their own under a specific set of circumstances where it was FDA that moved the regulatory goalpost, so to speak, wouldn't forfeit exclusivity as a result.
But under your theory, activist makes an application on January 1st, 2000, let's say. And then on January 2nd, the FDA changes some requirements. Now it's January 1st, 2050. They still haven't gotten approval. That's excused because the FDA made a change on the second day?
Certainly not automatically, Your Honor. The question would be, as of the 30-month date, first, was the applicant still working on the deficiency that FDA had? Was the applicant still working, excuse me?
Right. So imagine they were barreling towards a forfeiture and the day before the 30-month mark, they're just sitting there. Oh, gosh, we're about to forfeit. And the day before, out of nowhere, FDA changes requirement X that no one was even thinking about. That's the get out of jail concern with your rule.
I would push back on the characterization of it. That is how the rule as FDA currently applies it would operate. I would push back on the characterization of that as a get out of jail free card, Your Honor. It's a matter of...
It is an entirely a windfall from the perspective of the first applicant who had a fatal deficiency, let's just assume, because this is the rule you're advancing, on requirement A, and they are going to be denied. They're not going to be approved by the 30 months. And from their perspective, it is entirely fortuitous. And they are let off the hook because of something that doesn't change the fact that they never would have been approved anyway. It does seem, as Mr. Prince put it, completely backwards.
I think the way to understand this, Your Honor, is a little bit through the lens of a question that Judge Walker asked my colleague earlier, and understanding which way Congress intended to answer a particular question. So as Judge Walker noted, the classic reason, or this is a classic example of multiple sufficient causes for one thing. And the reason we generally don't apply but for cause in those situations is because you end up with a situation where effectively all of the causes are excused from having a particular effect. And here, Your Honor, if I can finish for a moment, the one cause that Congress identified as the cause it wanted to make sure wasn't excused for the effect it would have on preventing the application from being approved was FDA changing the requirements.
Well, I do think this is the whole question as to statutory context. It's essentially, who's the wrongdoer? What is the wrong thing? And is this provision, is the dominant thing it's saying that a bad product that can't get approval by 30 months, that product should not hold up the rest of the market? Seems like a pretty strong argument that's what they had in mind. Or were they more concerned with the possibility that someone with a bad product, but now they've also got to do some extra work for the FDA, that they want to make sure that person is off the hook for liability? And it is, if you think of this the other way, I think it's quite clear that Congress would want the independent failure of activists to get approval being a sufficient cause to be enough to warrant the consequence of forfeiture. If you look at it from that perspective, it's hard for me to see why in this, the hypothetical activists, I know this isn't the facts, why they are the ones this provision is sympathetic to, as opposed to everyone they're holding up.
It's telling, I think, Your Honor, that Congress didn't more generally carve out situations where the agency could in some way be thought of as the wrongdoer or at fault. Maybe it simply took a long time. Somebody was out on vacation in an inopportune moment. But Congress carved out a specific circumstance where an action by the agency through no fault of the applicants would cause the applicant to not obtain approval by a certain date. And Congress specifically called out that instance as when it wanted to excuse forfeiture. And FDA since it began applying this provision, this is its contemporaneous and continuous interpretation, has always treated that as erring on the side of treating, to borrow your phrase, treating FDA as the wrongdoer whose act we don't want to excuse the consequences of here.
If you were Congress and you had to disincentivize one of two possibilities, the first possibility is deficiencies in an application, and the second possibility is FDA improving the requirements in their application process. Seems like you would want to disincentivize the first of them because a deficiency in application is all cost, no benefit. On the other hand, the second of those, FDA improving their requirements, has some benefit, the improvement, although admittedly it comes with the cost of delaying the application. So wouldn't Congress have wanted to disincentivize the thing that's all cost and no benefit rather than the thing that's part cost, part benefit?
Your Honor, I'm not entirely sure I'm following your question.
If Congress had to choose between something that's all bad or something that's kind of bad and kind of good, wouldn't Congress have preferred the thing that's kind of bad and kind of good?
And in your view, I'm sorry that I think I lost the thread.
FDA improving the requirements of an application, that's kind of good and kind of bad. Activists submitting having a deficiency in its application, that deficiency is all bad, no good. So Congress would prefer to, if it's going to disincentivize one of those, it would want to disincentivize the deficiency in the application, the thing that's all bad, and not FDA improving the requirements of an application process, which is partly bad, partly good.
So
therefore recognizing that in causal terms, that you don't get you forfeit if your application is deficient, even if the FDA changed its tune midway.
Yes, thank you. Clarification.
Especially in the Hatch-Waxman context, Your Honor, where Congress is striking complicated balances in a policy area where I think a lot of reasonable minds could disagree about what the right path forward is. I think it's really important to resist the urge to reason backwards into the legal rule from what our intuition might be about a particular case. And here, Congress wrote a statute that uses a term caused by that this court has not previously held, has previously said it doesn't require but for cause of its own force. And the strongest contextual signal that the court has in front of it is FDA's unbroken contemporaneous interpretation of erring on the side of ensuring that the specific FDA action that Congress called out doesn't cause a forfeiture that, then the first applicant cannot get back.
So if we assume the case turns on contextual indications as to whether Congress wanted this rule to be but for or sufficient cause, it seems like so far in favor of sufficient cause, you've highlighted administrability concerns, which may be meaningful. And second, that this is the FDA's longstanding interpretation. Is there another contextual reason that you think favors? Those might be sufficient. I just want to make sure I have all the arguments.
The third contextual reason, I think this is the weakest of the three, candidly, is just the fact that Congress did call out this one specific type of agency action that would prevent an approval as the one to excuse forfeiture, and did not write a broader, anytime, you can point to the agency and say.
But you appreciate that setup does follow sort of the plain text structure of this provision, which is the default is forfeiture. And what you would expect to come after the unless is you might expect it to be a narrow exception, not a broad one. And a narrower exception would be served by requiring that to be a but-for cause.
I think it's narrow in the scope as compared to the scope of all of the ways that FDA's actions could, through no fault of an applicant's, prevent approval by a given.
Which is another way of saying this generally is a very harsh forfeiture provision.
Yes, I think generally it's quite a harsh forfeiture provision, but I think that generally it's quite a harsh forfeiture provision. But in some ways, Your Honor, we're not necessarily interpreting the full breadth of the harsh forfeiture provision. We're interpreting the specific point where Congress intended to be the forfeiture provision be less harsh. We're interpreting the scope of the excuse provision where Congress called out a specific instance. And this is in addition to the other two contextual reasons you identified, which frankly I think are our stronger ones.
I'll try one last time to so take as given, Congress thought it was a good excuse if you are delayed because FDA changed a requirement. What we're talking about is, should that person be off the hook where the good excuse made no difference? Would Congress want that person off the hook where the good excuse or not, they were going to forfeit?
This is why, Your Honor, I think the point that we were just discussing is the weakest of the three contextual reasons that we've discussed. There'd be massive administrability problems in terms of an agency trying to construct that but-for world, which largely, frankly, turns on information that an agency doesn't have access to about the amount of slack resources an applicant had, how clever that applicant's management might have been in reallocating resources, an applicant's general sophistication. And second, the unbroken contemporaneous FDA interpretation, which even in a post-Loper Bright world is a powerful indication, where the text is admittedly not fully determinate in a vacuum, is a powerful indication of what Congress would have meant.
You talk about this longstanding interpretation. Is there a regulation you can point to? How do we know what memorializes? When did FDA adopt that, and what memorializes it?
So I'm informed by my clients that this has been FDA's approach since the MMA was adopted in 2003. Because the MMA grandfathers in free 2003 applications, it didn't actually begin applying the approach until it got applications to which the new law applied sometime later.
But there's a public advisory that sets out the agency's interpretation of the statute.
There's a district court decision from the District of Columbia, I believe 2003, called Milan, which is cited in Teva's briefing, in which a district judge in this circuit upheld FDA's approach.
It doesn't involve a challenge to that standard, and it doesn't analyze the statute, though.
It does.
It reflects that it exists. I see. Yeah.
Yes, Your Honor, that's exactly my point.
Okay.
And if the court has no further questions, we'd ask that you affirm the judgment below.
Hello again, Mr. Killian.
Hello again, Your Honor. I'd just like to make a few quick points about the failure to market forfeiture. So Norwich frames the failure to market forfeiture as a dispute over which patents need to have forfeiture events. Is it those that activists P forward, or is it those that Norwich P forward in its application? Our position is that it's a red herring, that question, because either way the statute's interpreted, there have not been sufficient forfeiture events. If you go with, which we think is the correct interpretation of the statute, then Norwich's certifications shouldn't matter, because the forfeiture provision for failure to market forfeiture refers to the first applicant's qualifying certifications. And a qualifying certification, in the ordinary meaning of qualifying, is it makes someone eligible or meets the criteria to obtain something. And so the qualifying certifications, naturally read, would be the certifications that the first applicant submits on day one. And that's an important distinction, because I think, as one of your honors noted, it is possible that subsequent to the initial filing, the brand will post or put new patents into the Orange Book, and the first applicant may submit P4s for those subsequent patents. And so there may very well be, at the date of approval, a bundle of first day P4s and a bundle of subsequent P4s. And it's the first day P4s that qualify the first applicant for the 180-day exclusivity. That's the reference that we think the statute means. And so it's not a reference to activists' certifications. In no way does it make sense that activists' certifications would qualify. I'm sorry, I misspoke. I'm going to unwind that. In no sense, it doesn't make sense for it to be Norwich's certifications, because Norwich's certifications can't qualify activists for the exclusivity. Now, Judge Garcia, you asked a question about earlier whether, if two applications, the first and a subsequent, don't have any matching P4s, would we still be in the situation? And I think the answer is possibly, if they both have P4s, because that's how the coverage provision, eligibility provision, J5B4 is written. If the first applicant has such a certification, which is a reference to P4, and the subsequent applicant has a P4.
I understand that plain text argument. Why would that be a rule that makes sense? In that you would allow a prior, and I understand it's also not this case, but you would allow the first applicant the benefits of a broader sort of blocking force without taking on the burden of certifying to those patents.
Sure, but I think, Your Honor, the point is that the first applicant is strongly incentivized to bring as many P4s as possible. So I don't know that this scenario could come up all that often, but be that as it may, it would make sense that the first applicant who put itself out there, brought all the patent infringement litigation and got itself to the point, as this court has said, of, it's a pro-consumer device, this 180-day exclusivity. It is a reward to an extent. Now, I'd just like to turn briefly to the second point that I made, which is that even if Norwich's interpretation is correct and we look at Norwich's certifications only, there still have not been forfeiture events for the polymorph patents. And that's because while a second applicant can trigger failure to market forfeiture, the second applicant needs to have two things in order to do that. It needs to have a tentative approval of its ANDA, and it needs to have a finding that that ANDA doesn't infringe. And here, the problem is Norwich hasn't gotten both of those things for the polymorph patents. And this gets back to the stipulation that we talked about earlier and which we raised again in our brief here. What has been tentatively approved was the amended 369 ANDA. But the amended 369 ANDA is not covered by the stipulated judgment because the stipulated judgment says it only applies to the ANDA that if it's never amended. And so the congruence of having both a tentative approval and a judgment that that ANDA doesn't infringe is missing even on Norwich's interpretation.
And does anything hinge on the tentative approval part of that?
Yeah, in the sense that they have a tentative approval, but it is for the amended ANDA, which the terms of the stipulated judgment do not cover. The stipulated judgment says this applies.
So your argument is just the final judgment of non-infringement isn't binding here because of the amendment and the limitation on the stipulation.
Yeah, I wouldn't say isn't binding. I would say isn't applicable because by the way it is written, it applies to
something else.
Something else. So either way, Your Honor, I think our point is simply that the runway isn't clear under the failure to market provision. Salix's patents, the HE patent, which is certified in Activist's ANDA, and even the IBSD and polymorph patents, which even on Norwich's view, we think don't have sufficient forfeiture events. They remain obstacles to marketing, and so there hasn't been a failure to market. Thank you.
Morning, Your Honor. Brian Burgess for Teva Pharmaceuticals. I'm going to jump right into the tentative approval and causation issue, but I'm happy to entertain the court's questions on any topic. We don't think but-for is the right standard, and I also want to be clear that we don't think that there were independent deficiencies that would have blocked the approval of our application, or at least that that's not established in this record or decided by it. I don't want to get too drawn into the particulars of that, but I do think that those things work together because it shows in practice how difficult it is to disentangle the issues. One thing that was identified by Norwich's counsel was an inspection issue. Well, there wasn't an inspection on the 30-month deadline. That happened well after. We don't know what the inspection would have been on the 30-month day. And in fact, in the earlier notice to activists at a time where the agency was noting its new qualifications, there was no inspection issue identified there. So it becomes speculative and counterfactual. We also think the issue with the clinical studies, that's not separate from the change that occurred. FDA adopted broad new standards with respect to bioequivalence in 2017 that were certainly involved the dissolution studies, but weren't limited to that, included a whole new option 1, option 2 framework for when things were going to be required.
All this goes to if we think the FDA got but-for causation wrong, we should vacate and remand for them to consider all these things.
I think it certainly confirms that, but I think it also shows why but-for is not an administrable standard in this context, and it's not what you would have expected Congress to have intended here. The question of whether an inspection would have occurred and whether issues would have come up, it's just unknowable, and it's asking the agency to engage in speculation. Here there was an inspection, but in many instances, the agency won't even have engaged in an inspection if it finds there was a sufficient reason to preclude approval of the ANDA based on another reason, which could solely be based on its change.
So if it's not but-for causation, is there any quantum of causation that is required under your interpretation?
I think it's sufficient cause, which I do think is the interpretation that the agency has announced.
Puzzling counterfactual questions
I mean, there could be puzzling counterfactual questions in either direction. You know, to add Judge Garcia, you're asking for contextual clues about why one versus the other here. We certainly agree with the ones the government put forward. Another one that I think is important is on there, you could have multiple changes, for example, by the agency. It changes a requirement as to bioequivalence and it changes it as to product manufacturing. Imagine that those two changes are independently sufficient to block the approval. They could be the only changes. Otherwise, the applicant would have been on a glide path to approval. I think on their view, there would be a forfeiture here because you do have the two sufficient causes. And I think that's a real problem. Even in the hypothetical example where the windfall question you were asking, Judge Garcia, I think the problem is it's very difficult to know that in the abstract, whether there is going to be a deficiency. And so the question is whether Congress would have expected FDA to undertake that kind of inquiry here.
Are administrability reasons really going to be what decides this? I mean, just even deciding the record here shows defining it was a sufficient cause is sometimes difficult. You have to show that you were, you know, diligently addressing the requirement. You can't sit on it. It's going to involve factual questions either way.
It certainly will involve factual questions either way. The agency, and to answer a question earlier, the agency has set this out in guidance, how it applies the standard in 2017. You can also see it in the joint appendix at I think 168. They look at questions about.
Is that guidance cited? The 2017 guidance you just mentioned, is that cited? Do we have?
Yeah, no, it's in the record. We've cited it.
168?
I'm sorry. You can see it at Joint Appendix 168. It spans a few different pages, but this has been the agency's long settled interpretation. The agency has been, as to the question of what's administrable or not, the agency has been doing this for over a decade and has found that this standard is workable, and it's going to consider questions about whether the applicant was acting with diligence, what kind of change it was. Those can be factual inquiries.
Nice version of the question that I think Judge Walker and I were both asking, which is essentially that I read every single case and every restatement and treatise to say you shift from but for to sufficient cause when it's necessary to do so that a wrongdoer doesn't get off the hook. So Kilburn, Burridge, Barrage, every other case. And so if it seems to me, if that's the way to think about this case, then it matters whether I think from the statute's perspective, the person who was the applicant that was going to not receive approval if the FDA hadn't changed anything is the wrongdoer. And it's really hard for me to see a contextual purpose, common sense argument that from the perspective of this harsh forfeiture provision, that's not the wrongdoer. I'm not assigning blame.
No, sure.
I hope you understand the question.
Yeah, I mean, I think it's difficult to transpose the wrongdoer concept that applies in tort where you're going to have an adjudication of cause, which is not applicable in this administrative context. But
same thing in Kilburn, right? We're not going to say every state sponsor of terrorism is immune because there was more than one involved. And there's no necessary cause. And that's not necessarily in the tort context.
No, well, right, but the court didn't apply but for there, and nor did it consider it to be the default standard. It looked as to whether there were contextual indications that nonetheless it should apply but for, whereas I think where it's a default is in the adjudicative context where you're going to have a fact finder make these decisions based on discovery, these questions about when FDA counterfactually might have approved a product. It litigated in other contexts, like in antitrust cases, about whether there was a delay in generic approval.
In addition to the reasons that Judge Garcia was giving, there's a reason that we haven't talked about yet, late as it is, and that matters to me. You can tell me why it shouldn't. If an applicant has a deficiency in their initial application, and then later the FDA changes the requirements for an application, the sequence of those things seems to cut against you. And here's an analogy that I'm thinking of. It's the second, and I promise the last sports analogy for me for the day. But imagine we're trying to figure out the cause of a missed field goal in football. And as soon as the kicker kicks the ball, it's clearly going in the wrong direction. There's no way it's going to go through the field goals. And that to me is analogous to a deficient application submitted on day one. Imagine if while the ball's in the air, someone moves the field goal back a bit so that the distance is longer than the kicker kicked. I don't think any of us would think that it was the moving of the field goal back that caused the kick to be missed, when the kick was already going to be missed because it was in the wrong direction.
I think the problem with that is that the approval process isn't a one-time event. It's over a 30-month period where the applicant and the agency are engaged in an active dialogue. It is not the typical case that an application is fully approvable for the, as submitted. That's just not how it works in this industry. There's often a back and forth. And so the question is, outside of the whole framework being changed because the agency has adopted new requirements during the course of the approval process, would the applicant have been able to meet the 30-month deadline? Not was it, pristine on day one when it filed it, but whether it was going to be able to work with the agency to get it. And I just think it's unknowable when you have the agency changing the framework in a way that has cascading effects throughout the approval process that might have, because these things aren't happening separately. It's not as though you check one box and then move on. Everything interacts with each other.
I think related to that, but also related to what our remedy would be here if we disagree with you on but-for causation. I think I may have erred in how I read the briefs coming into this argument, because I thought there was an understanding from the briefs, kind of a unanimous agreement that activists would have failed to meet the 30-month deadline independent of the FDA rule change.
No, I don't agree with that. I think if you look at, for example, page 363 of the joint appendix, the agency, when it's engaged with this question, is saying because under our test, it was a sufficient reason that made it impossible for activists to secure approval by the 30-month deadline. Under our test, our analysis stops. So it didn't consider whether there were additional potential changes that were implicated in activists' inability to get it.
That page is not a page of the brief. I'm not saying that what you said isn't a winning argument on that point, but if Mr. Prinz gets back up here on rebuttal and he can point to a page in the FDA brief and the TEVA brief and the Salix brief that all concede that activists would have failed to meet the 30-month deadline independent of the FDA rule change. So
I understand.
What in your brief would you point to disprove that? It's kind of an unfair question because you don't know what he's going to say, but
this of course was the backup argument that they were making in their brief, and we devoted a corresponding amount of space to it. I don't think we ever conceded that we would lose under but-for. We just said it didn't matter, that the right way to approach this question is that a sufficient condition satisfies caused by under the ordinary meaning of that term. And to respond, I think, to the concerns about, I guess, a windfall or that it's a get out of jail free card and you're never going to have an issue. The provision doesn't operate in isolation. There are other bases for forfeiture that can come into play here. For example, the applicant has to diligently pursue its application. That argument was made to the agency. It decided it at 384 of the joint appendix. Norwich initially raised it in litigation and then dropped it when it saw the administrative record and evidently thought there was adequate support for the agency's determination on that. There's also, of course, the failure to market provision. I think an important context to keep in mind is the question of whether activists has tentative approval is not actually affecting whether activists can get into the market at the moment, because there's independently a patent barrier on the application that we filed. We were the first applicant. We engaged in litigation and were able to secure a settlement that lets us onto the market almost 2 years before the expiry of the last patent. Norwich, if it had succeeded in the challenge to that patent, could have forced a forfeiture under failure to market. It didn't. And it's still currently embroiled in litigation about whether its ANDA is going to be able to be approved or whether it infringes the patent, whereas activists has taken on the burden and is able to get onto the market earlier. To the extent we're unable to do that, or there's another ground for forfeiture, then Norwich would have a free pass. But we don't think that that's true here. And I also think it's important to note that the question of what happens after the 30-month date and is there ever an endpoint to this is not something that is really solved by the but-for versus the sufficient cause issue. You could have a but-for cause that takes an applicant years to address. You could have something that was the but-for cause at the 30-month date and then something new arises because the agency has changed its standards again, or there was an inspection issue that wouldn't have existed previously. This is a dynamic process.
I thought it was a problem that is caused by interpreting the caused by text the way that you interpret it.
Say that again. I'm sorry, Your Honor.
I understood the problem to be that if we take your interpretation of the text caused by, then it creates the problem that the process may play out for years and years and years and years with no negative consequence to the applicants who is causing it to play out much, much longer than it would have with or without the FDA requirements changing. And, you know, I did a 50-year hypothetical earlier, but even this case, we don't have to do a huge hypothetical. I mean, this case, I think your application was filed in what year? 2015? Am I?
That's right.
And here we are 9 years later, and I don't know how much longer.
Well, I mean, as I said, that fact has no real world implication about whether we're able to commercialize the product because we are barred by the patent. There are other reasons that there could be a forfeiture. If there truly was a clear path on the patents to which we had certified, then failure to market would come in. And if we don't get on the market within 75 days, then we forfeit in that instance. We're
8 years past the FDA rule change, right?
Right, but I think there's no way you can read a tolling rule into the statute. And the point we're
just trying to figure out what Congress intended by caused by, and I mean, you think they intended?
Well, I guess the point I was making is that the but-for versus sufficient clause is just orthogonal to that. It doesn't get at it because you could have a change that is undisputedly a but-for clause at the 30-month date that then takes the applicant many years to address. And you know, this is just an on-off switch. The way
it seems like the more common thing that would happen is that they change requirement B, and you've got a huge problem on requirement A, and 30 months comes and goes. So this basis for forfeiture evaporates, and we're here 6 years later while you're trying to meet requirement A.
Well, I guess my point is that it evaporates regardless. It is an on-off switch at that time. And reasonable minds can disagree about how, as we noted in the final page of our brief, there have been legislative proposals to have an option for subsequent applicants to potentially get on the market just based on the passage of time, rather than having an exception for changes in requirements. The agency, I believe, has supported that. The Trade Association for Generics has strongly opposed it. I think that they would have a pretty good idea of what on the whole is good for the industry rather than individual applicants, because they think it would dilute the 180-day exclusivity incentive. And I guess maybe I'll close with that. I mean, Judge Walker, you asked the question about on one side, we have this negative consequence. On the other side, there's nothing on the balance. I just don't think that's correct, because it suggests that the 180-day exclusivity is something Congress wanted to limit and that it's pernicious and should be narrowed as much as it can be. And I don't think that's consistent with the court's.
They wanted to use it to incentivize non-deficient applicants to submit non-deficient applications.
They did, but for the 180-day exclusivity to work, it needs to be predictable and certain. And when you have a complicated causal question that it's going to be very difficult to know how the agency might come out on a but-for scenario, it will have the effect of diluting the value of that 180-day exclusivity, which is what Congress adopted as the tool to promote generic entry earlier overall in the aggregate. Thank you.
Thank you. And I think we get to hear one more time from Mr. Prince.
Just a few points. Thank you, Your Honor. So we totally acknowledge that there could be difficult cases in teasing out causation. I think those concerns are overstated. Remember, FDA is always going to be looking at this backwards, it's going to know whether it would have approved the application or not. And it does a similar but-for causation analysis, for example, when it's applying 355Q of the statute, which is the other provision that's asking if there's been a delay due to a citizen petition. So it's already familiar with doing but cause. But whatever difficulty there could be in some other case, I mean, this is not it. Judge Walker, you asked like if we clearly teed up that this wasn't approvable regardless. And the answer is yes at page 50 to 52 of our opening brief. Actavis acknowledges that at page 45 of its brief and never contests it. And the answer why they never contest it is blindingly obvious in this case. FDA told them in 2017, this is a JA 507-512, it's a complete response letter, your application is unapprovable at this time. And I don't want to go into the details a lot, but one of them was a microbial issue, and the other was the missing clinical endpoint study that FDA had required since 2012. The site for that is at JA 385. Then again, Actavis fought very hard not to have to fix those things, and it tried to get around them. And you can see this through the record documents, which I can give you every one if you want. But it suffices to point out to JA 565, which is the 2018 complete approval letter issued shortly after the forfeiture deadline had passed. And FDA says it's still unapprovable for the same reasons. It's unapprovable. And then it's years later today, and guess what? They still don't have approval because their application is unapprovable. There's no argument at all that this change in requirements had anything to do at all with their failure.
From our perspective, those might be reasons you will win straight away when it goes back to the FDA. But the counter, at least on what we would do if we agree with your legal test, is to say this is an APA case. The FDA made a legal error, but it has not yet applied the but-for test. We set aside its action and send it back to the agency.
I certainly acknowledge that you could do that, Your Honor. I think the record here.
More than that?
I think when the record is absolutely clear and there's only one outcome on remand and the issue hasn't been disputed, and I think if you read the briefs carefully, you'll actually see that it hasn't been, you can conclude that there's been a tentative approval. And what we don't want to do, again, this is critically important to get this drug on the market, and we've been running around in circles now for years. And if you just remand, we're going to be back in a black hole for some period of time. So I could understand why you would do it that way. You applied the wrong legal standard. But if you do, we would ask that you set a short deadline for FDA to act on remand so that we can move this forward. There's no other questions. I appreciate the court's time.
Thank you. The case is submitted.
Before it was meant to be tomorrow at 9:30 a.m.